Okay, good morning. We are starting this workshop that is Pier Luigi Parco. We are at the CNPF here in Florence, and we are starting this workshop on the reflection on the new draft proposal of the protection of media pluralism and independence in the EU that has been presented at the European Media Freedom Act. This proposal is very important and will deserve and will create a lot of discussion in the next months, while the Parliament and the Council will prepare for their own contribution to this new piece of law. But clearly there's also space for a discussion that is a discussion between academics, between stakeholders, between media, between platforms. Many subjects are involved in this discussion and will continue the debate about these issues. So this the proposal today is of this workshop, and the concept of this workshop is to examine some of the aspects of the proposal. The proposal clearly is a very complex and important piece of law, as I say, and there's different aspects that really need to be understood and discussed in particular. The idea today is to use the workshop to face three different issues. They are all pieces of this complex legislation, but they have to stay together somehow, and that's why we decided to dedicate 1 hour to each of these three elements, trying to connect and begin a deeper discussion on these elements. Let me mention also that this is one step in a discussion that we will develop in the next months, and we have already another workshop that is not directly on the ENFA, but on the media pluralism online study that we prepare for the Commission with a group of other European universities that can be considered one of the backgrounds of the ENFA elaboration. And this discussion will be the 13th of December. It will be again online and in person and online, so it will be hybrid, so it will be open. So and there we will, as I said, we will discuss again some of the aspects of the ENFA, but with probably more an academic effort to go deeper on certain aspects of the basis of the ENFA. While today the idea is also to discuss the issues, but also to gather opinions and positions by different stakeholders that will have a role both in the development of the ENFA, but then later on in the application also of this legislation. So let me introduce very quickly the three themes that we will be discussing. As I say, the ENFA is a very complex legislation and touches on many issues. The first part of today, we will concentrate on the market measures that are in ENFA. Let me say that somehow we use as a reference point our own activity, the Media Pluralism Monitor, and our study of the media assets. So both two of the issues that are in ENFA, Article 6 and Article 21. Article 6 that is about duties of the media service providers, and these are two kinds of duties, duties in terms of transparency. of ownership, of final ownership and so on, and also duties about the organization, the independence of the editorial decision, are for us part of the market plurality, the market organization normally of the media sector, and clearly part of the market organization of the media sector is also Article 21 of the ENFA that is about assessment of media market concentration. So we see these two things strictly connected in the way in which we look at the things. So we'll have a first part of the discussion that will be about the transparency issue and the organization somehow of the media enterprise, that is this question of the independence of the individual editorial decision and the disclosure of conflict of interest, so again, transparency. And then this part of the discussion that is about the ENFA role toward mergers in the media market. This is clearly an innovative part of the ENFA, because is a part that is born for two elements. One is the divergence that also the Media Pluralism Online study showed in many countries that had some legislation about media concentration, not based on competition, but based on media issues specifically. But this legislation was very variegated and dishomogeneous in the European countries, in many European countries, in the countries in which there was this legislation, because many didn't have. So it was really a quite scattered situation. And the ENFA is entering on this by the suggestion of having new rules at national level and on this on media market concentration with a new media pluralism test. This is a very interesting and deep element of discussion, a new media pluralism test different from competition. So this is really what ENFA is aiming at, and we think this was also somehow in the Media Pluralism Online study suggested, and so we think that this is a very interesting way to go, but clearly needs to be seriously discussed how to find the content and the standard for this for the application of this idea. And this will be essentially this transparency, editorial organization, and market and the market concentration will be the first part of the meeting. Then the second part of the meeting, we will move to a discussion that is, if I can say, a bit more institutional and traditional also in a sense, because as in other sectors, the ENFA is proposing a step ahead in the organization of a new board for media service that is a sort of organization of the way in which a peer review, a collaboration among media authorities in Europe, in the EU countries, is organized and works. Clearly, ENFA builds on the past, builds on ERGA. This is a transformation of the ERGA that was already there, and that had also a role in the preparation of the ENFA proposal. And the idea is to transform ERGA in a European board for media services, defining the independence of the board, Article 9, the structure of the board in Article 10, the role of the Secretariat that will be assured by the Commission in Article 11, and the tasks. It's very interesting, is not different from other sectors, need to be put in relation with what is already in other sectors about this. Clearly, there is a discussion about the fact if the Commission went too far, that if there is too much intervention of the Commission, or if the Commission didn't go far enough, if there was the need for an agency for more harmonization, more coordination. Somehow, this proposal is design a possible middle ground among these two positions, and it's very interesting to see also some of the actors that will be present today. How do they think about this? Finally, and I don't want to take too much time, the last part of the discussion will be about the content of media service providers and the relation with very large online platforms. Here, the ENFA is innovative because while we all know that there was a long discussion during the DSA about the possibility to have a media exemption for media in the relation with platforms and the possibility of platform to take down content created by media. This wasn't in the end within the DSA, but somehow ENFA is proposing again a new solution. This solution is in Article 17, in which ENFA is saying that there should be essentially a special treatment somehow. It's not really a full media exemption, but is a special treatment for the media content in the relation with the platform and in the way in which platform act. And the first step of this is a sort of the creation of this instrument through which the platform allow media to declare themselves as a media service provider, that they have an editorial independence, and they are subject to regulatory requirements for the exercise of the editorial responsibility. That means design what is a media in a sense, in some sense. It gives an instrument to have this sort of self-declaration, and then there are consequences that these consequences essentially are of the kind that the content that comes from this media cannot be dealt as any content, but needs, if platform need to intervene for any reason, they justify the suspension of this content, that there is the sort of organized dialogue for how to discuss this. The board that we have just mentioned will be informed about this exchange between this media and platforms. And so there is a series of, I would say, procedural guarantees in this thing. And by the way, the Commission is also expected probably to issue guidelines on this, on the form, the details of this relation. Is not a media exemption, but is a step somehow in recognizing that content that comes from media that are organized through editorial responsibility, through a situation of editorial independence, that are organized as media, is not generic content that can be dealt by the platform as any other content. So even here there is a tension because, again, it's a new thing and the relation is complex and definitely deserves a discussion. I think that all these three themes are three pieces of the ENFA proposal. It's not all there. There are other parts, but for today we decided this is enough on our table for the discussion. The way in which this discussion will be conducted is that one of our researchers will introduce the discussion on each of the three themes. Then there is some intervention that are in the program by generally important stakeholders of these issues. And at the end, Anna Errol for the Commission will comment the discussion. So there will be an open discussion and then a final comment of a few minutes by the Commission of each of the three teams. I think that that's the formula. Let's hope it works. And I give the floor to Roberta Carlini that will start.
Thank you, Pierluigi, and good morning, everybody. So the first session is about the market measures in the European Media Freedom Act. As told by Professor Parcu, there are many relevant measures to be discussed, but market in some way informs all the act being based as a legal basis is on the internal market, on the functioning of the internal market. The issues that are that will be discussed, so all the overall regulation aims to the well functioning of the internal market in the digital era and on the role of the media. But the articles that specifically deal with what we can define as market measures are the Article 6 and Article 21. Professor Parcu already synthesized those articles that will be discussed in the first session. What I want to stress in my introduction is just that two things. The first thing is that those measures are aimed to the functioning of the market, but of course, they have a broader scope because transparency of media ownership and editorial independence are also can also be seen by the point of view of the right of readers, consumers, and citizens to have a correct information and the functioning of the democracy. And the second article that will be discussed in this session is also very, for the first time, it is introduced at European level, the principle that the market dominance in the media sector has to be considered in a different way. The competition tools and competition policy that of course is there to stay and is in parallel, an assessment that has to be done is not enough. We need a further assessment and examination. The second thing that I want to stress to introduce this debate is that following all the preparation and the consultation and the positions of the stakeholders in the preparation of the Act, it is quite surprising that the discussions focused on Article 6 more than on the media market assessment. Maybe it is because it's a very sensitive issue. For the first, press is included in this regulation for the first time in many countries. It is not regulated from this point of view. And second, maybe because also there is the recommendation that has been published together with the proposal, which provides a catalog of best practice to assess, to guarantee transparency and editorial independence. There is a debate, there is a discussion, that in the industry, we will hear the voice of industry, of the media players in the market, and of civil society. I have to announce, unfortunately, that Mr. Karimi Burki, chair of the European Regulators Group of Audiovisual Media Services, cannot join because at the very last minute he had a change of schedule, and he apologizes with all the participants. So we have this first session in which we will first hear from Harold Giles, Senior EU policy officer of the Association of Commercial Television and Video on Demand Service in Europe. So he has to represent as the voice of audiovisual industry. And Maria Luisa Stasi, Head of Law and Policy for Digital Markets of Article 19. Mr. Gilles, the stage is yours.
Thank you. I hope you can hear me. I'm going to assume that's a yes. Thank you very much for the invitation. So yes, I'm Gilles with the ACT. I'll preface my intervention by a disclaimer that we're still in the process of finalizing our formal position on the MFA. So we've given it a lot of thought and we're quite close, but we're not there yet. So I hope you will forgive me if I don't go in too many details and that you don't hold me too accountable to it, but we're almost there. So to start off, I did want to say that the ACT supports the Commission's ambitions of promoting and protecting EU media pluralism, independence, and sustainability to ensure a well-functioning EU media market. We do believe that the MFA has the potential to be an important milestone in devising a sort of new social contract between media and government in an increasingly digital environment. And in our view, the most effective way for the MFA to achieve this is by putting in place a principle-based framework that helps guide a coherent approach to media pluralism, independence, and sustainability in the EU, whilst respecting local market differences and without establishing additional minimum requirements at EU level. So as such, we do welcome the Commission's choice to legislate via a regulation rather than a directive here. Now, I know you want to focus this panel on what you call market measures, and in particular, Article 6 and 21. But to start off, I did want to just make a quick point that we do believe that a key element that is missing from the MFA in this regard, so from the perspective of the market, is a strong statement that media service providers are free to provide their services in Europe. Whilst this is in theory already the case for the fields coordinated by the AVMSD, national laws in other areas, and I'm thinking in particular, for instance, of licensing, can and sometimes are used in a protectionist manner to prevent or discourage media companies from entering media markets. We would therefore see value in spelling this out outright and upfront and in an independent article, essentially that there is freedom to provide media services in the EU's internal market. I know that there is a reference in Article 4, but we see value in having that as its own thing, let's say. So now, second, you did mention that you wanted me to speak about Article 6. So measures to improve the transparency of media ownership could indeed be useful from our perspective. ACT members are already transparent about their ownership, structure, and funding. So we do embrace the inclusion of these measures in the text. Of course, the devil will be in the details, but we see no issue with what is proposed by the Commission here. On the editorial independence point, well, our members do abide by the highest ethical standards and are comfortable with errors being transparently identified and addressed. But a wide variety of frameworks do exist. But the bottom line is that more often than not, this is an obligation that we do have that is enshrined in or backed by national law or constitutional orders. And they're often a condition in our license anyway. So we can support the overarching principle in the text, but we do believe that specifics must be left to media companies themselves in self-regulation, possibly under the oversight of independent regulators. And it's too bad that we don't have Karim today to discuss this, but ultimately we do not believe that this should be, that essentially the specifics should be delegated to legislators and be in great details in the MFA. So we can support the principle, but maybe not too many details, let's say. And in our view, it's worth noting that according to, well, the Media Pluralism Monitor, so I'm talking to the good crowd here, we saw that essentially those countries that score the highest in terms of media pluralism tend to be those that rely mostly on self-regulation. I'm thinking about the Nordics in particular and Germany. So to summarize on this point, principles okay, but threats tread with caution and not undermine existing systems. Finally, with regards to Article 21, from our perspective, it's absolutely key that European broadcasters be able to scale up and partner up to ensure that they're able to compete with global online platforms. Legal safeguards on media concentration already do exist via EU competition law, and they are complemented by sectoral regulation in many member states, in particular when it comes to us. Sometimes they're related to acquisitions, but in many cases, they're actually tied with market entry or the allocation of licenses. And these rules do vary widely across the EU, but ultimately, their existence is a prerogative of member states. From our experience, we know that where these rules are present, or not present, sorry, for instance, in Nordic countries, the market are usually both efficient and pluralistic. That on the contrary, such requirement where they do exist can be quite intrusive, disproportionate, and often outdated. Therefore, we do not believe that there is a need for the MFA to develop harmonized EU regulation in this area. And this could be quite detrimental to national markets that function well. Here we're open to common principles where those rules do exist to ensure that they reflect the reality of the information market as a whole, but not full harmonization as is proposed essentially in the proposal. From our perspective, concentrations that are actually the most problematic from a media pluralism and sustainability perspective are those of large tech companies, which are allowed to continuously acquire companies whilst at the same time, essentially providing the digital interface for media consumption and advertising. And this essentially is done without any objections ever being raised in terms of the impact this can have on the media market and on media pluralism. We've seen quite a few examples of quite problematic concentrations by a large tech company, which benefit from significant competitive and regulatory asymmetries. So for instance, Amazon's acquisition of MGM and Twitch, which do impact our sectors. And whilst those two companies that I just mentioned are technically not media companies, they do distribute and produce media content and are therefore part of the broader media environment. Whilst the DSA and the DMA will address certain aspects of the unfair competitive advantage that platforms benefit from, they will not do so from the angle of media pluralism. And we do believe that it's important that this shift and the resulting impact on media pluralism and media sustainability be also addressed in the MFA. So I'll stop at this. I know that there's maybe sometimes, I don't know if you want me to touch some other points. I know there was a third speaker, so just let me know. I'm happy to cut it there, but
due to the, thank you, Mr. No, due to the absence of Mr. Burki, you can have 2 minutes to more if you want, but you can also step in the discussion as you prefer.
So maybe just one point. I think that I didn't plan on talking about today, but that one that's quite relevant from our perspective in terms of the market is well, first, we do believe that the framework set out by the MFA, and I think it's a bit related to the next panel, but not really, the framework through which national authorities submit and justify draft legislative initiative or measures in general, and the board issues opinions. We think that's quite positive from a market perspective. We consider that the primary interference in the freedom to provide media services in the internal market actually does come from some member states. And this ranges, from disproportionate or inadequate measures to direct and indirect state influence in the media landscape. And in particular, we think that the implementation at the national level of the minimum requirements foreseen in the AVMSD are being used to essentially erect market barriers, which undermine our ability to move into new markets. So from a market perspective, this is definitely something we want to be reinforced in the text, the relationship between essentially Article 20 and the AVMSD. But that's just what I did want to say on this one. I don't know if that's something we want to discuss today or not, but that's an important point for us. Ultimately, we do think that the MFA should thrive to essentially try to address existing regulatory asymmetries, be it, through essentially the media pluralism tests that do exist in some member states, but also in terms of the regulation of the sector, but it should not reinforce them. So there is an issue of scope that we think will need to be addressed. And I'll stop it here.
Thank you. Thank you also for anticipating with clear words the official position that of ACT that is going to be published in a few days, I think. And now I give the floor to Maria Luisa Stasi from Article 19. Are you here, Maria Luisa?
Yes, I'm here. I hope you can hear me. Good morning, everybody.
Yes.
Thank you so much for the invitation. Thank you for having me here. And thank you, Aaron, also for setting the scene and raising so many good points. I have, as Roberta said, I'm head of law and policy for digital markets at Article 19, which is a free speech organization. So as you can imagine, our perspective is very much the one of welcoming an instrument that aims to achieve more media freedom, independence, and pluralism in Europe, of course. So I just want to kick off and start by saying that this is something absolutely needed in Europe for a number of reasons, not only economic reasons, but also reasons related to the resilience of the democracy. But I think there will be consensus on this, at least among many in the room. So I'm not going to go into this. I'll just try to focus and give some inputs on the two elements that we're supposed to discuss in this panel based on Pierluigi's introduction as well. I have to say that especially, I'm going to focus especially on the media pluralism test because I'm a competition lawyer by background, so that's my piece of cake, let's say. I don't have a lot of answers, but I think I can, I'll try to raise a couple of good points for discussions, at least. My premise is the Media Freedom Act is, the proposal is a complex proposal. It has a lot of things in there and it tries to address a number of challenges. So I do believe that it's important also to think about the administrability of this proposal and how it will actually work in practice. And this is what I've tried to do while thinking about the points that I wanted to raise today, to go from the proposal, from the theory to the practice, and see where we could have some challenges. So on Article 6.1, I think what the European Data Protection Supervisor has recently said in its opinion is a valid point, specifically the fact that because we're talking about transparency for public interest, it might be worth it to explicitly mention what is a public interest to sort of give a better idea of what's the scope. I also think that the explicit mention to the fact that the information should be easily and directly accessible to the recipients is good, very good. It is also, I think, is a step forward in the current situation because sometimes this information is available, possibly not easily and directly accessible by the public, by the general public, but only by the regulators, for example, or by specific stakeholders, but not everybody. So this, I think, it's a very good improvement that we have in there. There are two elements, though, that I would like to raise. It seems to me that when it comes to easily and directly accessible, it's sort of we need to consider also the fact that the information needs to be meaningful. Meaningful is a term that is being used in plenty of discussions, current discussions in Europe about transparency measures in regulatory framework, from the AI Act to the DSA, the DMA, etc. What I think we need, it might be a little bit more accurate to discuss rather than meaningful information is sort of a qualified, transparency qualified, because it needs to be qualified, then the point is maybe we need indication in Article 6, or at least we need guidelines in that sense. I also, let me note another thing. I do believe that the scope of the article might be slightly problematic, because we do have this duty is attributed to media service provider that provides news and current affair. I wonder whether we might want, I know those are concepts where there are a number of standards available at international level, regional level, where we could look at in order to identify what falls inside and what falls outside. But I note that there is no definition in Article 2 about those two concepts. So maybe if those are those concepts are a key element for the application of the provision, we need to figure out how to make sure that they are interpreted and understood in the same way across the markets. So for what concerns on the other side, there is also this element on Article 6 too, about the individual editorial decisions. I think that individual, and this is something that I'm going to go back when we're discussing the media plurality test and the editorial independence. I think the individual editorial decision is vital, of course, for the media and the journalists to be able to perform their watchdog function. But I also think that we might want to go a little bit broader than that, and the recommendations, they do go broader than that, and they look at the overall editorial line, or at least it seems to me. So I wonder why we have this sort of mismatch in the Article 6 and the recommendations, and if this is the best way to go. On the media plurality test, so once again, it's a very welcome step. It's enough to notice how fragmented the current scenario is across the member states. So this will be, per se, I suppose, a very good improvement. There are a couple of elements, once again, when I was trying to bring this from the theory to practice and wondering how will work in concrete cases, that attracted my attention. Let's start with the definitions. The definition of the media mergers in the proposal, it refers to mergers involving at least one media service provider. So here I need to echo what Erard just said, which is there might be other mergers that will have a strong impact on media plurality, but yet they won't involve one media service provider. And so I was wondering if this is a gap that in any way we're ready to fill, and if you ask me, we should be ready to fill, but it seems to be to fall outside the Media Freedom Act, and I wonder how else we can cover it if we don't do it with this proposal. There is another, on the good side, it seems to be a definition that does not require overlap. So usually the competition assessment happens on overlapping when there is an overlap between the acquirer and the acquired, because this is what defines their markets. So there it seems to be a little bit broader. The requirement to communicate the merger, I've noted that Article 20 talks about the requirement to communicate it to the relevant authorities and bodies using the plural, which might be a way to say that it's assumed that the structural and procedural rules about the media plurality test will address or will be applied and enforced by more than one regulator or body, which once again seems to me to suggest that possibly the idea is that the competition authority, they will keep leading on a competition assessment, and then the media authority will probably step in with a sort of an assessment for the media plurality, providing this in the form of an opinion or an advice, etc., etc. So this seems to be what is in the mind of the drafter. By no means, I don't want to put any words in their mouth, but this is my interpretation of what I read, at least. Why I think this is important, because I do believe, and I'll talk about it a little bit more in details when we come to the criteria. But I do believe that the overall comment on that I can make on the media plurality is that there will be cases where there will be a conflict between media plurality and competitiveness, or they will simply not be fully aligned. And the idea is to try to figure out if there is a priority to respect and to which of the two we will need to give priority. Now, if the system, the way the system is thought is to still have the competition authority having the lead, and then the media plurality assessment to become an extra layer of the assessment, but in an advisory or in an opinion form, then possibly this means that we're not changing the priorities. We're just systematizing the fact that it will be an extra layer of assessment, which could be enough, or it couldn't be enough. This is to be seen. But just to share the way I read it. On the criteria, first of all, I have to say that I very much like the approach of the Commission of putting already these 3 main criteria in there. I think it's possibly a couple of things just for discussion. What I like is on 2 elements. One is that when looking at the impact of concentration on media pluralism, the authorities are supposed to take into account the online environment. This, to me, I read this in a very positive way. It seems to me that this infers that the look should go at the entire media ecosystem, at the value chain in its broader sense, which is a sort of a way to compensate the fact that other kind of mergers that will have an impact on media pluralism, they're not going to fall into this the scope of this article. The obvious point will be, looking at the relationship between the very large online platforms and the media service providers. The other element that I like is this reference to the effects on the formation of public opinion. I think it's super relevant. On the other side, I am afraid that this formation, the effect on the formation of public opinion is not nothing. It's not something where we have clear criteria or measurements instruments. So we might need to get to this yet, and especially we might need to make sure that this is interpreted and applied in an harmonized way across the different member states. I note that the Commission is supposed to develop some guidelines assisted by the board, and my point here would be that it might be open to discussion whether it should be the Commission leading in this role rather than the board, considering that one of the tasks, the specific task attributed to the board in this regulation is the one to promote best practices and look at best practices around the states. And I do believe that although there is a fragmented situation in the different member states, we do have some best practices when it comes to the criteria. I think about Ireland that has recently introduced 3 criteria in their competition rules related to the assessment of media mergers. And also, it seems to me, but this might be a wrong interpretation, that if we look at when the Commission is supposed to step in the assessment of media mergers, the Commission is the only one for which Article 21 does not explicitly, Article 21 and 22, sorry, do not explicitly provide that the opinion that the Commission is supposed to issue on the matter should be based on those criteria. So we might be in a situation where the Commission needs to issue the guidelines on how these criteria will need to be applied, but the Commission is also the only one that is not supposed to be limited in its assessment to those criteria. It might be just a way to interpret those rules that is open to discussion, of course. The last point I wanted to make, and I thank you for the patience, and I'll take advantage of these 2 extra minutes for the unfortunate absence of Karim, is that Article 21 seems to refer to the 2 different situations, and this is similar to what we have when it comes to national measures. Not only, so it's not the first time that we have this in the Media Freedom Act. We do have two situations. One situation is the national, the media merger is national. It stays into the national boundaries. It doesn't affect the internal market. And there, the threshold which is relevant is the significant impact on media pluralism and editorial independence. And the authorities in the country, they should make this assessment based on the criteria in Article 21, and possibly the guidelines that will be developed by the Commission or the Board. We will see. They do it, end of the story. If, on the contrary, the media merger does affect the functioning of the internal market, then the national authority is obliged to consult the Board, or the Board can, upon request of the Commission, issue its own opinion on the impact on media plurality and independence, and then the Commission can also issue an opinion. What I'm trying to say is that while on each and every case where there will be an effect on the functioning of the internal market, there will be two more layers of scrutiny, or at least there will be potentially two more opinions, the Board and the Commission one. But when this is considered to be limited to the national level, none of this is going to happen. Now, we do have a lot of case law we can look at to consider when there's been when a merger is affecting the functioning of the internal market. Still, this might be interpreted in different ways by the different authorities. And this might be potentially a way to strongly reduce the impact of this media plurality test. Sorry, not the media plurality test, but the impact of the system of peer-to-peer pressure, which I think is one of the added value of the Media Freedom Act at this stage. I do realize that this is extremely linked to the legal basis and to the fact that it's difficult to foresee a system for strong intervention when it's about national cases, purely national cases. But I wonder if in an online environment, we do really have any national-only cases anymore. I'll stop here. I'm happy to take questions or clarify points, and I hope my inputs were useful. Thank you.
Thank you so much, Maria Luisa and Harold, for pointing out a lot of topics out of these two articles that are very relevant, on which I quickly open the discussion. And we have a lot of participants online, so even though we know each other very well, a lot of us know people very well, but I'd ask you to qualify your name and appartenance when you speak, or you can even pose some question in the chat. So is there anybody who wants to start the discussion? I ask for help to Sophia because I don't see the chat from here. There's no questions. No questions. So. Let's wait some minutes. We also have questions and comments here, but due to the high number of participants online, I'd wait from some signals.
And there is a question from Marco Botta. Marco, would you like me to read it, or do you want to directly intervene?
Yes. Hello, everybody. I would like to ask a question to Maria Luisa. So about Article 21, about the system of control for media concentration. So my understanding, Article 21 is addressed to member states. So as you said, it will create an additional system layer of control of media concentration in parallel to the national system of mergers control. But my question is, what will be the impact and the situation when we have media concentration that have a community dimension notified directly to the Commission under the Mergers Control Regulation 139/2004. So in my view, but maybe I'm wrong, there will not be this additional control on the Commission decisions, let's say. So how this would happen, or how this will take place, I mean, in your view?
Thank you. Thank you, Marco. I think this is one of the most interesting points, because Article 21 explicitly says that this sort of new system does not affect Regulation 139 of 2004, which makes me think that when the merger has a community dimension, then the Commission will still proceed exactly as it does now. I would say the way I read it is that in any case, the media authority, if it is a media authority or the responsible authority or body within the member state, will need to provide an assessment on the media plurality, on the significant impact on media plurality. And this is so because, as I mentioned, the plural is used, and so it makes me think that this will be dealt by two different authorities. And so if we have a community dimension, what is going to be absent is going to be the assessment of the competition, the national competition authority, but possibly the assessment of the national media authority will still be issued. Now, the problem is, and I agree, it might be a challenge, definitely, how and if this will be communicated to the Commission, and if the Commission will ever need to take this into account. Yes, I agree. This should be clarified.
Thank you.
Thank you, Marco and Maria Luisa. And are there any questions from the participants? I see that Einar Hallen. Yes, please.
Yes, hello, good morning. My name is Einar. I'm representing Schibsted, a media company in the Nordics, owning media businesses in Norway and Sweden, and also owns different digital services. My comment is about Article 6, because this is not sensitive for us at all. We have had in Norway and quite similar in the other Nordic countries, have had agreement between the media owners, the publishers, and the editors for many years, regulating the publishers' roles and the editors' roles, and have been securing the independence for editorial content from intervention from the owners as well as from other parties. In Norway, we have had this agreement back in, I think it was signed in 1953, and a few years ago we had this new Media Responsibility Act that also incorporated this principle in the form of a law. My question and my comment is really about why the Commission have chosen to do this so unclear and complicated in Article 6. What's the reason behind leaving this to the owners to come up with measures to secure editorial freedom and independence? Why not state this in the clear language and make it more clear and easy to understand what should be the role of the publishers and what should be the role of the editors? I think that's unnecessary, complicated, and could make problems for different media owners and editors as well. So that's really my comment and question.
Thank you. Thank you. This is a very sensitive issue that has been often raised by countries in which such self-regulation already exists, in opposition to countries in which there are not self-regulatory measures. We, as a Media Pluralism Monitor, we have this observatory on a comparison on all over the country. I really look forward to the intervention of Anna Errol to explain also how this article is meant to address the different situation in the different countries. But are there other questions and comments, interventions, please? Eva.
Thank you. I would just like to build up briefly on something that Maria Luisa said in her intervention, and I think it's very important for the Article 21 and the assessment of concentration in media market and the need for this exercise to take into account the online environment and possible effects on opinion forming power or the formation of public opinion. And there is another related part of the ENFA proposal, which deals with reliability of audience data needed for the market assessment. But it seems to me that the proposal as it is now doesn't deal enough with the need for the availability of market data, both in traditional and in online markets, in order for such assessment to take place. So I was wondering what your views are on this, whether there should be any improvement with this. And also, I'm sure Roberta can say much more, but in the Media Pluralism Monitor, this is the obstacle that we face because this data is not easily available or is not available at all in many markets across the EU.
Yes, just to briefly comment on this. What can I say? I totally endorse your point, and I've seen closely enough how difficult it is to make sense of the little data that are available out there, especially because, as you said, there is a lot of fragmentation of what you can have or cannot have, and also they're provided in different metrics, etc. I think it's not by coincidence that a number of media regulators in the different member states, they've tried to figure out, they've been struggling with methodologies to measure essential elements in media markets simply because the data were not there. I suppose there are two ways to proceed. The first one is to try to give more power to the regulators. I'm oversimplifying, of course, to give more powers to the regulators to go and ask for the specific data that they need. And then the regulators should be able to do the majority of the work to make them comparable, to give meaning to them, etc., etc. But the other way would be more towards trying to establish specific rules for the variety of actors that have this data, that produce this data. And I say on purpose variety of actors because I don't think it's just the media service providers. I think we need this can be this sort of a challenge can be expanded to a number of markets and a number of layers of the media ecosystem. So if basically what I'm trying to say is that if we want to be ambitious, let's be ambitious for real and expand it to many other areas. And I see that there is a difficulty in the Media Freedom Act to try to achieve this this goal. And I think I perceived something very, very similar also in other regulatory initiatives like the DSA and the DMA. To be honest, I don't think in any of those proposals, in any of those regulations now, there is a strong and complete answer to this question and this challenge.
Pierluigi?
No, Well, I wanted to say something. Seems to me that Article 21 is clearly an article that is creating or aiming at a parallel system respect to competition law. The problem is that the system is sketched in this article. I was mocking that this is an article about self-harmonization because it says to the member state that they shall provide in their national legal system substantive a procedural rule which ensure an assessment. So somehow is said to member state to do it. Then, however, is said also that there will be there could be guidelines, there could be there is a process. So somehow I think that this is an article in the making. But my feeling is that this is aiming to create a parallel instrument to competition law. So that these two things are, and this is explicitly said, by the way, at least in the negative, that this is not about competition law. This creates a new way to look at these media mergers. The question is, first, what are media mergers? And that's one point we were discussing, and we'll have to discuss more. It's clearly said that it's enough that one media is involved here. So media mergers are not mergers between media, but are mergers that affect the media market. And for the moment, it seems to me that what is saying is that at least one media must be involved. And there is a reasonable question if this is sufficient or not, what is really asking. The second thing that I see important here is national mergers that Maria Luisa was mentioning versus cross-border mergers. And it's also an element. However, the tradition of competition law and the way in which the single market has been interpreted helps, because we know that this interpretation of the EU relevance has always been very extensive. So if a merger change situation in a country, that's of relevance for EU law. So I don't think that this is, but however, this is not EU law because we are asking the countries to design their own system. So I think we'll see an evolution of this. And finally, but this really on the background, the true question is that this is going to substitute what we saw in the media pluralism, in the media plurality online study, a complicated and very differentiated situation in member states. Some member states didn't have any law, others have had pieces of this media pluralism test legislation, very different, very scattered, very particular, very old also, very outdated often. However, one thing I have to say, that these pieces, some of these pieces, add something about the fact that they don't want market dominance in media. This is not here at the moment. Here is talking about mergers. So the issue, if there can be market dominance, opinion power control, and so on in a member state, is an issue that will surface in the making of this and in the future. And I think that is a very serious issue. And so I think that we are opening a discussion, and probably this is a first piece of law, but we really have to see how it will be realized.
Okay, we are in the last 15 minutes of this session, and I would add, okay, I would just for a moment dismiss the role of moderator to ask a question to our speakers. That is about, we are examining separately Article 6 and Article 91. But in among the criteria to evaluate of the media pluralism test, there is also the the editorial independence and the guarantees for editorial independence in the new company born by the merger has to be taken into consideration. So my question is if, according to this criteria, it would be possible to allow a merger in case in which it guarantees internally editorial independence of the new company, substituting external pluralism with internal pluralism. And this is something that I was we were discussing here internally, and I forward these doubts to our speakers that are all qualified to give their precious input. And I see that Maria Luisa wants to speak again, and I'll ask also Errol, what does he think of these questions that have been posed here, and then I will give the floor to Anna Herold.
Yes, thank you, Roberta. I wanted to come back on this issue of dominance that Pierluigi raised, but I think I can also include something on your very good question. So I totally agree that there is an issue of dominance which is left unchecked, and also this comes in the form of question every time so far I've discussed the media mergers. One of the questions that has been asked is what do we do with the mergers that have been already authorized and they had a huge impact on media plurality? So this goes in the same direction. I just wanted to say and to add that I think a role will be played also by the third criteria in Article 21. So this idea of the sustainability, because if on the one side is absolutely it's an idea that I totally endorse, that we need to look at the economic sustainability, because we know that the economic sustainability challenges that are typical in media mergers. On the other side, I was wondering whether this is a sort of failing film defense, and if we can simply go and look at the case law of media mergers in general, and use exactly the same criteria if we need something different, because in those criteria the media plurality of course was not one of the elements, and this might be also relevant for the dominance, because if we end up having a very loose interpretation of what is required to ensure the economic sustainability, then we can basically put everything in that basket and keep having dominance, or keep creating dominance in the markets. And I think for the editorial independence, I read the test as being a test, an assessment I read the article as mandating an assessment on media plurality and editorial independence, not or, and that "and" is something that gives a message. Or at least I want to find a message in there, and I want to think we need one and the other. So that maybe that possibly could be used as a shield to avoid that, as long as editorial independence is guaranteed and we can sort of assume that there is internal diversity, then we can forget about external diversity. Hopefully this could be one of the ways to interpret it.
Okay, thank you, Isa. Errol, do you want to add something?
Sure. Thank you. Thank you for the floor. I mean, from our perspective, at the end of the day, what we don't want is a situation where we have additional procedures, exactly as one of the earlier speakers, but I think it was Luigi who said this, additional procedures that would roll parallel to the competition law assessment. That is, from our perspective, very much a worst case situation. As I was saying earlier, the trend is that we actually do need to consolidate if we want to be able to compete with global platforms. So for us, we're a bit worried about where this might go, and I hear it's all very sort of academic? How can we make the ties between the different articles? How can we reinforce this? But from our perspective, that's a bit besides the point. We know, and I was mentioned earlier, that these types of procedures do exist, and they've existed for a long time. Most of the time they're outdated, and actually in a number of countries, I think that in the Netherlands, for instance, they've started sort of repealing them because there's a recognition that there is a need for more scale. So I find it a bit worrying that we're going in exactly the opposite direction in this regard by trying to create new procedures. So, I mean, at the end of the day, we'll need to look at this closely in the discussions around the text. But in our view, if we stick to sort of principles that can guide national legislation when it does exist, so it's sort of more fit for purpose in the future, that can be fine. But mandating new procedures as is foreseen, as it is, that's a bit problematic from our perspective. Now, when it comes to the link between Article 6 and 21, I mean, I do see the point. I do see that there is probably a link. I'm not sure that that's necessarily something we want to do. As I mentioned earlier, for us, the principle is fine, but ultimately it's more an assessment that, or a dialogue that needs to happen between the media and the regulator to see if the necessarily sort of safeguards are in place. It's not always going to happen in the context of a merger. Again, I was mentioning, I know, for instance, in France, that's part of the license. I think that's the case in Italy too, but I know less the Italian system. But in many countries, that's sort of part of our license to operate anyway. So tying all of this with sort of procedures that can limit consolidation where it's needed, I would be wary of doing this. But at the end of the day, I say this, and we're still not fully done with our position. So it's a bit hard to go into too many specifics and sort of subsections of Article 21. I can tell you the way we're thinking about it is to sort of broaden the scope of the article by saying not just media service providers, but media service providers and and very large online platforms in the criteria, and adding a sort of perhaps, again, we'll see, qualifying elements of when these mergers do affect significantly media pluralism, right? So they're sort of building on the definition, so it's a wider concept, but not tying this to specific obligations to create procedures, but more sort of tool to reassess existing laws where they do exist. But everything will be, I think, a bit clear in the next few weeks when everybody sort of is able to comment on the specifics, and I'm happy to keep the discussion going on that.
Okay, thank you. And we hope to participate to this clarification with the discussion. So I will give the floor now to Anna Herold to comment this first session, very, very rich of insights from different point of views. Anna, the stage is yours.
Yes, good morning, everyone. I hope you can hear me well. So it's been indeed a pleasure to listen already to this initial points of view, both rather positive. So of course, it's quite reassuring. Okay, so I have a challenging task because I think I have 4 minutes until the end of the session, and I have to respond to many issues that were raised. So I'll try, but of course I will not be complete. So maybe first I wanted to thank the Center for calling the session, how should I put it, giving a broad focus in the session to several aspects of EMFA and calling it media market measures, or market measures as you called it, because in the end this is what it is about, and actually the entire EMFA is about the media markets. And this is, I think, an important, I fully understand we are here among experts that for years have studied media pluralism as such, but of course the only angle from which the Commission can approach issues related to media pluralism and editorial independence is of course the internal markets. I think it's good if we start, you know, how should I put it, go a little bit to the basics, and I think that will also help understand what the reasoning and what the rationale of the Commission's measures is. And this is twofold. It's on the one hand to try to look at the different existing rules that may pertain to media pluralism directly or in general affect the operation of media service providers, and see whether they create obstacles in the exercise of the economic activities in the internal market, or create distortions of competition. So this is the starting point. So I think I just want to make clear that whatever we are putting in place in ENFA has this in mind. Of course, it can have, and we all hope, a positive impact on media pluralism, editorial independence, and media freedom more in general. But this is not the objective of the legislations per se. So this is very important, I think, for everybody to have in mind. And just, maybe to comment a little bit on this last point by Erard, that of course it's very interesting to discuss the details, and actually we welcome, and it was extremely interesting, the interpretation by Maria Luisa of Article 20, to hear the interpretation of Article 21, which I think is we would fully share. But it's obvious that from the Commission's perspective, the idea here is not to introduce necessarily additional level of regulation for the purpose of media pluralism. Our angle, our starting point is completely different. We are looking at the different rules that exist, that have been referred, and the study that Pierluigi has mentioned, of course, helped us to a bit map what we have in the different member states, including the fact that in some member states there might be very little or nothing. So we see both, problems that stem from the absence of rules, but we also have see first and foremost problems with the existence of these rules. And what we are trying to do is to put in place, and it is true, a very principle-based harmonization. So Pierluigi is absolutely right in his. I think you referred to this as some sort of self-harmonization. Maybe that's a bit, we would say that we are a little bit more ambitious than that, but certainly this is the idea, is to try to have, let's say, a light harmonization at EU level of what exists, but at least something that may be meaningful for the media market players and provide an additional level of legal certainty. And it is certainly not, and that allows me maybe also to try to address the point by Roberta, it is certainly not, and also by Erard, it is certainly not meant as an additional anti-concentration tool as such, or forcing, additional anti-concentration tools within the member states. The idea is to make sure that, that when such assessments, and we do think that they should be taking place, or at least there should be possibility for them to take place, they indeed are done in a relatively consistent way. And we do recognize that we are providing only certain elements in the proposal, and we leave a lot to the member states, but also to the possible guidelines by the Commission in cooperation with the board. But we are trying, to gradually coordinate these different assessments for the benefit of the media market players. And the idea is that it is not supposed to prevent necessarily concentrations taking place, but making sure, as Roberta and we have discussed a little bit, this reference to editorial independence, that maybe certain safeguards are introduced in those discussions with the responsible authorities, and in particular media regulators that should be at least involved. These could relate indeed to certain safeguards in terms of editorial separation, the future existence of separate editorial programs. So we know that these type of issues are being discussed with media regulators in the context of such assessments, and we think that this could be one of the ways to ensure that in the end, the primary objective of such assessments, which is, that we continue to have access to a range of competing views and informational products, continues to be available to people on the market, be it because of the variety of players, or because of the internal pluralism that would continue to be ensured. So I hope that I tried to at least a bit explain the rationale. So it's not supposed to make life more complicated for media market players, but hopefully also easier, but ensure that kind of, you know, a safety net is there in all member states. So that would be on the why. Then we had a discussion, and I'm still on Article 21. I will briefly go back to Article 6 at the end and with one sentence. So on the what, because there has been an interesting discussion whether our definition of media market concentration is enough. What we have, first of all, I think we are taking a very broad definition from our own rules from the merger regulation. So on the point of Pierluigi, yes, we are not tackling abuse of dominant positions. But we all know we are not talking about merger sensu stricto, but we're also talking about ownership changes because we have this broad definition of concentration in the media regulation. Then we have indeed this condition of at least one media service providers being involved in that operation, which would exclude let's say operations between or ownership changes among pure digital players. So this goes without saying, but I think an important element to bear in mind that, as we clarify in one of the recitals at the beginning of the proposal, some of those players we have in mind, so be it video sharing platforms or very large online platforms, started providing as part of their services media services. So something that can really be qualified already under the either the current definition that we already have for audiovisual content in the directive, or the new definition that we will have hopefully in ENFA, editorially controlled services, sections as part of the section. So some of the players on the market, I think I don't have to tell you which ones, they do already provide media as sections of their service, and they would then be covered by the definition already. So that's just one. And then the second point, I think Maria Luisa on that online element that she did notice this element of the online environment that we have included in one of the let's say elements for the criteria, guiding criteria in ENFA, that indeed is meant also to look at the presence of these digital players in the context of media market concentrations. So then maybe one sentence about the how, because there has been a lot of discussions on this. So as I think you will have noted very well, we are trying to harmonize a great variety of systems, whereby some member states have a separate tracks for this media pluralism test, and in some there is the media regulator is involved in some ways in the work of the competition authority. And we would like, we do not want most of the member states to change anything, or maybe just, let's say, integrate their systems into the new coordinated systems that we are trying to put in place at the European level. So we would cover this variety of the different situations, and we would certainly not force member states to put in place completely new laws and systems. So a system whereby a media regulator is consulted by the competition authorities, clearly, as Maria Luisa, I think, have very eloquently described, is fully covered by the mechanism we are trying to put in place. And on the relationship with the EU merger rules, I think you will have noted that we do not want to impact, as we don't want to impact the work of the competition regulators in terms, of their deadlines. So, for example, in case member states will have to make, those that do not have anything in place, will have to involve as the minimum their media regulators in these significant media market concentrations. they will have to, of course, fit it into the procedures that exist at national level. And the same goes for the EU merger proceedings. We don't want to change what DG Competition is doing with the mergers with community dimension. One last sentence on Article 6, because this was also discussed. So just to reassure again that that we in a way we are codifying the best practices that already exist and that were referred to by both ERART and I think EINAR. And I think you will have noticed an extremely flexible character of this article, of Article 6.2. Now I speak specifically about 6.2. While I noted, of course, what Maria Luisa was telling us about the transparency obligation. So on that, I think it is very visible that the Commission is not trying to, impose any single concrete measures or mechanism, but is trying really to encourage further take-up of such measures within media companies. And if we didn't get something right, as Einar was saying, that we have put in place a language that is too complicated and doesn't actually reflect the reality of what is happening between the different people involved, between the publisher, owner, shareholder, or whoever else there can be in terms of having stakes in a media service provider and editors, that we understand very broadly, as you will have seen. Then we are happy to express it better, because this is not supposed to change the understanding of the current safeguards that already exist within media companies that both ERART and EINAR have been referring to. So I stop here because, of course, it's a lot of ground, and we'll stay with you for the rest of the discussion.
Thank you very much, Anna. And now we can start the second session of the day. It's about the new board for media services. Good morning from my side too. I'm Elda Brogi. And I briefly introduce the topic of the second session, and then I will leave the floor to our distinguished speakers of today. Giacomo La Sorella, the president of the Autorità per le Garanzie nelle Comunicazioni, and the Italian Authority for Communications, and vice chair of ERGA, the European Regulatory Group for Audiovisual Media Services, Nicholas Moskakis, a senior policy advisor of the European Publishers Council, and Renate Schroeder, the director of the European Federation of Journalists. The topic of today, of this session, is discussing about the establishment, the role of the new board for media services. That is one of the novelties of the European Media Freedom Act. And I must say that is somehow the backbone of the whole act, considering that a lot of competences in order to implement and make the act operative and implemented are on this board, on this new board. So, as Center for Media Pluralism and Media Freedom, we have stressed a lot of times, many times in our reports, in the reports of the Media Pluralism Monitor, in the last study on media plurality and diversity online, the need of more coordination of the national media authorities when it comes to the governance of the broader media market, the internal market, the European media market. So we welcome very much this initiative of having the European Board for Media Services, also because we think it is relevant, it is important to acknowledge that the media market has changed, that it is now affected a lot by the new digital environment, the competition, as it was said before, with online platforms, and in particular very online or very large online platforms, for instance, when it comes to resources of the system. And we can acknowledge the importance of a coordinated activity. Also, we have acknowledged it in the recent months when, for instance, there was a need to intervene in cases of in the cases of Russia Today and Sputnik. And there was a regulation coming from the European Union, I mean, banning these media outlets. But in any case, I mean, we stressed a lot also in our internal discussion how this kind of tasks are very connected with the role of the media authorities in implementation of European law itself. So, for instance, in this sense, to a better cooperation could be needed. We realize in our study that not all the authorities have the same resources, not all the authorities have the same independence in different member states. Highlighting these issues, we again see in a very positive way the establishment of the European Board of Media Services, and we stress how the competences of this new board are very large, broad, and very important, because they go from regulatory competences, technical or practical interventions on aspects of media regulation. They issue opinions on market concentration, likely to affect the functioning of the internal market. The board is asked to coordinate actions with regard to media service provider not following EU media standards, cooperate with other NRAs, issue guidelines on market concentration and media pluralism, exchange of best practices. So there are a lot of very important competences that are somehow the core of the implementation of the Media Freedom Act. So whether it is an improvement that the European Media Freedom Act forces for more cooperation, harmonization, and peer reviewing through the establishment of this board, some of the issues that we may discuss today are related, for instance, and this is the way to open the discussion. The harmonization of the remit at national level. Is there a need, considering that the European Media Freedom Act is not limited to audiovisual media services, whether the establishment of this board should require also harmonization of the remit at national level? If the board, as conceived by the Act, can be considered enough in order to tackle the many, I mean, in order to work on the many competences that are foreseen by the Act, or whether a different structure should be envisaged, whether the resources that are devoted at national level to media authorities can be somehow revised and boosted in order to have an effective implementation of the Act, considering the level of the board. whether we have to raise an issue of independence of the media authorities and how to frame the independence of the board itself, and what is the role of the Commission within the board, and the relationship with other authorities and maybe with other pieces of regulation that are in the pipeline or were approved by the European Union that envisage a coordination of authorities for what concerns other competences. Without further ado, I leave the floor to Giacomo La Sorella for his presentation. Thank you very much.
Thank you very much. First of all, good morning to all of you. Let me start by thanking European University Institute and in particular Professor Parco and our moderator, Professor Brogi, for organizing this event and for offering the opportunity to share views and discuss the main novelties of the European Media Freedom Act. These are crucial times for the media regulation, and the choices that are being made today probably are going to mark the future of the market for many years to come. The program of this panel is concentrated on Article 8 and 12. I'm glad to take the floor and provide my views from twofold perspective of the Italian communicator regulator and of ERGA, which I'm vice chair, and I will assume the chairmanship next year. ERGA is going to, from the design of ERGA will come out this new European Board for Media Services. So we are very much involved in this process. We are also issuing a position paper on the EMFA. I will not obviously comment or anticipate this this position paper, and obviously I will only express my view, but I obviously wanted to inform you that we are going to express this position paper. I think it is appropriate to recall the main aim of the Commission proposal, expressly identified in the need to reinforce broader regulatory cooperation and to ensure an harmonized approach across member states as far as the pursuit of substantive goal of the EMFA are concerned. I'm thinking of media pluralism and media independence, as well as protection of users of media services from illegal and harmful contents. Academics and stakeholders were already saying 10 years ago that boundaries between audiovisual sector and electronic communication sector were progressively blurring, but only very recently, with the evolution of the internet and the mass diffusion of the IP technology, new services and new operators such as on-demand services and digital platforms started to gain a considerable market size. It is well known that these new services and new business model vehiculate information, allow consumers to broadcast self-generated content, offer enterprises the possibility to gather data on the preferences of their customers, and ultimately promote high advertising investments. Hence, they have become extremely important for the growth of the ICT industry and in the perception of end users. Such a phenomenon does not only blur the boundaries between the audiovisual and the electronic communication sectors, it seems to have an impact also of the geographical borders, since several services and audiovisual content are available to all of us, and they are offered by operators that are not settled in the same country or even in the continent where they are consumed. Besides, these new media service providers take advantage of the country of origin principles, but at the same time behave and are settled in each national market as national operators. So the frame is quite complex, and it is very important to tackle it with a regulatory act like the European Media Services, Media Freedom Act. And it's also important to ask what role the national regulator should have today and to what extent it, which means we could reinforce it through cooperation among NRAs and with the European Commission. This is the question that the European Commission addresses in Article 8.12 of the EMFA, after introducing for the first time regulation of video sharing platform with AVMS directive and the regulation of digital services with the DSA. The Commission decided to expand the fields of intervention of national regulators and try to foster the cooperation among these regulators by creating the European Board for Media Services. This is a very useful approach which we completely share. And it's important that the Commission has done this because no other national regulator could have done it, nor it has been done outside the EU. But it is important to underline that the European Board for Media Services is not a brand new platform. That's not come out of the blue. It is actually built upon the foundations of Article 30 of the AVMSD, which establishes the existing European Regulators Group of the audiovisual. It is absolutely true what Professor Burger was saying, that we need to harmonize the competences of each national regulator, but ERGA already provides the frame for this upgrade of competences. There are the European Media Freedom Act involves a very important enhancements of the present competences of ERGA. Professor Burgi was already outlining them, the possibility to issue opinion on national measures and decisions affecting media markets and media market concentration, and moreover, the powers of investigation to request information to all types of media companies, online and offline. And another significant improvement is the creation of a specified structured cooperation procedure, about which we will discuss in the next session, which institutionalized the provision of the Memorandum of Understanding that ERGA has adopted last year on a voluntary basis, which has been already an achievement carried out by the NRAs themselves. The board established by Article 8 is called in charge to assure a swift and effective cooperation among NRAs and between them and the Commission. Among this positive development, however, there are several issues regarding the board which may require some fine-tuning. In the light of the time constraint of today's discussion, I will only focus on two major aspects. The first one relates to the independence of the board. Such independence is correctly affirmed in Article 9. In other parts of the Act, there are several provisions contained, for instance, in Article 12, that seems to suggest that the board could be activated and its activities delivered upon request or in agreement with the Commission and with similar formulas. Maybe there's room for improvement. With there's the possibility to improve this wording. The ERGA has always worked in perfect agreement with the Commission, and there's no doubt that the new board will do the same. However, a sound and future-proof institutional layout cannot rely on common sense consideration, and also for the benefit of the board and the working of the Act, of the provisions contained in the Act, it is important to assure to preserve more strictly the board independent from any institution, in some ways also with regard to the European Commission. Furthermore, it has already emerged in practice that the recent legislative process dealing with media issues ERGA is acquired based on its member NRA's day-to-day regulatory experience, a large expertise, and more an important role of trusted institutional advisor for all EU institutions. So it would be advisable to enhance, to consolidate this role, and that this role will be formalized within the new board mandate. The second issue strictly relates to the first one and refers to the composition of the Secretariat pursuant to Article 11. Given the extensive new mission and remit of the board compared to ERGA, it's essential for the board to rely on a strong and independent Secretariat, which must be able not only to support the activity of the board itself, but also to provide mutualized support for the NRAs, especially the smaller one. Already Professor Brogi was talking of this problem of different forces, let's say, among NRAs. Precisely for this reason, EDGCOM, in its response to the ENFA public consultation, has emphasized the importance of giving the new platforms of regulation an appropriate status and full independent human resources management, responding solely to the assembly of the NRA. From this point of view, while it must be recognized that this setup proposed by the ENFA does strengthen the Secretariat, I believe that the proposed solution does not is not still sufficient, because it still relies on staff hired by the Commission that responds to the Commission rather than to the board itself. Naturally, we are still at the very early stage of the discussion, so it is worthwhile to consider the new institutional design with a holistic approach, and there is not optimal institutional model in itself. There are different models of different bodies in the galaxy of the European institutional system, and maybe there can be further improvement for the model chosen for the new board. Besides all this, I want to conclude to be clear that I'm firmly convinced that ENFA is a very good proposal overall, and it introduces provisions that are forward-looking and extremely useful to preserve pluralism in the online and the cross-border environment. I hope that the proposed regulation will be soon adopted by co-legislators, and I'm quite sure that there will be room to fine-tune and improve the aspects that I've mentioned as far as Article 8, 12 are concerned. Thank you very much for your attention.
Thank you very much for this clear intervention, and for bringing the point of view of the authorities. And I give the floor now to Nicholas Moskakis, of the European Publisher Council, to hear the voice of publishers of the industry. Thank you. Nicholas, are you here?
Oh, and good morning.
Here you are. I see you. Great. Please, the floor is yours.
Thank you for the invitation and for the excellent discussion until now. Just also to say, we are kind of in the same position as the ACT. So we are still discussing and analyzing the proposal. I must say, perhaps it's the shortest proposal we ever worked on. It's only 28 articles, but then it's still proven to be quite complicated with a lot of ramification in different areas. So we would like to be sure that we have a solid and sound understanding of it. For the EPC, just to say a couple of words, we are a high-level group of CEOs and chief executive of the 28 leading media companies in Europe. And our members, they are active in a variety of fields. So from publishers with newspapers, magazines, books, but also audiovisual, and of course, digital presence in various formats. So with regard specifically of the European Board for Media Services, this is amongst our priorities. As we know, the national media regulators, which in practice are regulators that monitor audiovisual media, they will become the board and will replace indeed ERGA. But our fear is because the MFA goes beyond licensed media, such as broadcasters, and includes press publishers, and we all know that the press publishers have a special role and they fall under other protection of the law, and they are subject to self-regulatory codes of practice and not under national regulators. We are afraid of potential implication that this change for the free press. And while the Commission has explained to us that the press will not come under the scrutiny of the board, it's a little bit hard to understand how that could be guaranteed, given that the board, as already mentioned, is responsible for the effective and consistent application of this regulation and has a say on specific articles, as for example, we discussed in the previous panel, Article 21. So given that the press, it is part of the ecosystem, it means that one way or another will be affected. And of course, we are now at the first step of this regulation. So we only see the text coming out of the European Commission. This will be amended by the co-legislators. And indeed, there is no guarantee, for example, that Article 6 will not come under the auspices of the board. So this is one concern that we have. And of course, we are actually afraid of potential use by some national governments to use this opportunity in order to undermine the independency of the press. So this is a really key issue for us. Just to link with the discussion that we had earlier, we would also prefer that the board's role on media pluralism opinions in relation to media mergers and acquisition, we feel that this should be best to be left at the national competition authorities, or at least to have a priority on that. My second point has to do with the independence of the board, as Mr. La Solera has laid out before. So Article 9 talks about the independence of the board, which is something that we absolutely support. However, on one hand, we feel that the MFA does not foresee any strengthening of the rules or guarantees of regulators at national level. This is still left or linked at the AVMS, and definitely there are some issues there, as you mentioned, Professor Roghi, earlier. On the other hand, the other point that we see about independency is the strong role, if I can say, that the Commission has secured to play within the board. And there are 6 instances that I would like to highlight. So the European Commission, as you know, they will have a representative in the board. They will participate in all activities and meeting of the board. They will be providing indeed the secretariat of the board. And we'll have to agree whether or not the board will invite an expert and observers to attend its meeting. So that's a bit peculiar. And also 3 instances, the board can draw up opinions only with the agreement of the Commission, as laid out in Article 12E. And the Commission can also request the opinion of the board on 2 other instances, both related to the internal market for media services, which is also a point that we are not very much clear. So overall, we see that there is quite a heavy involvement of an institution on an independent authority, which, by the way, does not also, the MFA does not give the ability to such institution to issue opinion for a topic they consider important. So it is not clear if, for example, the board by their own initiative could draw up an opinion of a topic that is of their interest. So my final point is actually has to do with their resources. So we see that the remit of the national media regulator is becoming more and more demanding. they now will have to oversee compliance with national media regulators, the laws that they are transposing, the Audiovisual Media Services Directive. They will have to contribute to the effective implementation of the DSA, but also they have to be part of the DMA high-level group. And although Article 7.3 refers to the adequate resources and technical resources that member states should provide for the national audiovisual authorities, perhaps this is not enough or will only happen in some member states and not all. And we should look into how to make sure that the authorities have enough resources in order to properly do their job. Thank you.
Thank you very much, Nicholas. My first comment is that we have to start from somewhere, because I think that this harmonization is needed, considering the structure of the market that is really becoming not only European but global. I mean, there are these new actors that really are changing somehow the way we used to conceive the media sector, and also the distinction between press, media, traditional media, so on and so forth. But I leave now the floor to Renate Schroeder for the European Federation of Journalists. Thank you.
Thank you very much. Thank you, Elda. Thank you for being at this very important panel on behalf of the EFJ. Just shortly, we are also in the middle of finalizing our position. We are in close contact with our affiliates in all of EU member states. I have 3 issues to discuss here within the 5-minute spot, and I'm sorry to repeat, or not, I'm sorry, I think it confirms repeating myself on a few issues like the independence, because it's very important. And I'm happy that with the publishers, we also have a few points where we have common ground. So yes, first, we need to ensure the independence from the European Commission of the board and propose, as we had done in our submission, the sub-option B, meaning a governance system that is based on a board assisted by an independent EU office. Second, and that was also said by Nicholas, yes, we need to fix the problem of the lack of independent NRRs, either by law or by practice. And I just referred to the very important CMPF data that says, well, there are 5 member states that have no transparent objectives and are not independent. There are an additional 11 member states that are independent by law, that are transparent by law, but it's not implemented. And third point, we need to be clear about the tasks of the board, but also its enforcement possibilities and its limits. Is it to be an oversight or just an advisory board? So on the first point, just give me some very concrete proposals for improvement, because I think the independence of the board, where also I feel ERGA agrees to, is rather easy to fix. On Article 10.5, for example, I would add after the point, the representative of the Commission shall participate in all activities and meetings of the board without voting rights, that the board, where it believes it's relevant, can meet without the presence of the European Commission. I think that would be important. I feel we agree in this panel that wherever it said in agreement with the Commission, that could be deleted. We all agree that the board shall have an independent secretariat, as I said before. And where applicable, it should be added on initiative of a board member or the request by the Commission. I feel that initiative by the board is very important. Then on Article 21.3, we discussed a lot before the question of media market concentration. We believe it should be turned around. The board, assisted by the Commission, should issue these guidelines, instead of the commission assisted by the board. Maybe something to discuss. And just another point on structural dialogue, there should be also professional organization and specifically academics invited. Nicolas also mentioned the importance of inviting experts to the meetings. On point 2, yes, we believe the European Commission has failed to address the systematic problem being the lack of independent national authorities, specifically, I'm afraid to say, in Central Eastern Europe. Unfortunately, there has not been any improvement when it comes to strengthening the independence of national authorities, though it has been specifically mentioned, and we were very happy it has, in the revision of the Audiovisual Media Service Directive, aiming to reinforce their independence from political and commercial interests. The reform, and you know, Article 30 and 30A includes, and I repeat it because it's important, a requirement for member states to designate one or more independent regulatory media authorities legally distinct from the executive power and functionally and effectively independent of their respective governments and of any other public or private body. Article 7.3 does not explicitly mention the procedures for appointment of their members, which have the potential to work both as levers for exerting pressure and as guarantees of independence. The board is expected to exercise, and I think it has been said before, pressure through its informal power. Based on its professional authority, we call it peer pressure, and result from the internal negotiations in order to reach the 2/3 majority they need to have decisions. However, and I may be wrong, but I believe such peer pressure, sorry. Sorry, I have a problem here. We doubt, however, that such peer pressure has a positive impact on errors that are often captured by the state. Of course, cooperation is needed, but it may not be enough. In sum, we believe more safeguards are needed, including that all decisions of NRR should comply with the requirements of media freedom and pluralism. The catch-22 is that furnishing NRRs with further powers and resources could even be counterproductive if those authorities are captured by the ruling party. Such bodies may be instructed by their governments to form the media landscape according to the ruling party's direct political interest. So one example, and Elda already mentioned something, could the DSA and maybe the role of the national coordinators of the digital services, who have an important role at national level and must work independently and in full transparency, be an example here to follow, as probably in future they have to work much more together. This is a question, I have no answer, but as agreed by my predecessors, a holistic approach should be envisaged. So just a last word on the new board and its more tasks, which should be more clearly defined and should have a bigger coordinating role. I think we all agree. It should have an extended mandate justified by the perceived lack of coordination and developing new standards on media pluralism and freedom across the EU, including third country media services and the treatment of content by very large platforms to replace and improve the ERGA, a subject that will be discussed in the next session. It shall give opinions, and we have already talked about it today, in more types of cases, but opinions just remain that, opinions. We believe its powers are not substantially strengthened. For example, it will not have powers to make a difference in case media pluralism is systematically curbed in one or more of the member states. It seems Anna Herold said that this is not to be the aim of the Media Freedom Act, but we would like to have a bit more insight in that. So my question again, is the board to be an oversight board with more powers or a purely advisory board? I believe the success of the EMFA will depend on an efficient, effective oversight, much depending on its expertise, its reputation, its independence, and transparency. Thank you very much.
Thank you very much, Renate. We have really few minutes for a couple of questions, and then I would leave the floor to Anna Herod because it's almost, I mean, we have 10 minutes left. So is there any pressing question? Otherwise, I think that considering that a lot of questions were raised, maybe we can leave the floor to Anna. Any question from the floor? So I think we can ask Anna to react to these three presentations. Thanks.
Yes, thank you. So maybe, and I fully see that there are, to a certain extent, of course, how to put it, very different opinions on the role of the board that have been expressed in the panel discussion. So maybe going back to what we have discovered in the extensive public consultation that, of course, prepared our proposal. So it was very clear that there was no appetite for creating a central, strong oversight body responsible for media regulatory and even less so media pluralism issues at EU level. I think that this has to be very clear. I fully hear and I recognize that there has been, and Renata has explained, of course, at one side of the spectrum, voices that were calling for a stronger role for such for an authority at the EU level, but it was not the let's say overarching call. So it was clear that we are trying to here providing a solution that corresponds to the majority in the public consultation, and it was very clear that this majority has been in agreement with the reinforcement of the current coordinating role of the expert group that ERGA is. So currently the ERGA is a commission expert group, and trying to give it more resources, tasks and responsibilities, but still, and I want to be very clear about it, as a strong but an advisory board at the EU level. So this has to be very clear. And I think that this is very clear also when you look at the nature of the opinions that the new board will have be formulating according to EMFA, that I think is very clear, will not be binding, although we think that because of this federated voice of view of authoritative view of European media regulators together will carry a lot of reputational weight. So this is the solution that we are now we have now put on the table and which we are discussing. So that of course also puts into perspective all the other elements, including one of the, how should I put it, main practical element that has been already debated in the panel, which is the type of support that the new board will be getting. So again, here I want to be extremely clear. We have looked very seriously at the different models that exist at an EU level for bodies, for similar bodies. And it was, after a very careful assessment of the different options, that we have decided against creating a specific agency that would act as an independent secretariat to the board for efficiency and cost effectiveness reasons. We have one example at EU level where a similar body in the, and this, you know, the eminent representative of regulators knows very well. Giacomo La Sorella, of course, as representing converged regulators, sits also in the other body that we have in the telecom sector. And this is a solution that has been found for the telecom sector at the time. However, the solution, as you know, is very costly and also has a long setup, and I think a long timing. So so it has on the cost side, it's a very high overhead costs, because you have to have a specific administrative services, and at the same time that cannot be shared with those from the Commission, and at the same time, so apart from the fact that it's costly, it also takes a long time to set up. And I think we all agree that here we are talking about issues that are extremely urgent to address. So I think we cannot afford, you know, waiting another 2 years after ENFA hopefully is adopted for the board to become operational, because basically this is what would happen, you know, if we were to go. I think it has to be very clear for everybody calling for the independent secretariat for the board, that it means setting up a mini agency that are very rare in the European in the system of the European agencies. So the, let's say, the BEREC office that is an agency is an anomaly. It's one of the smallest, if not the smallest, agency that exists, and that would take a long time to set up. So I think that this is something, you know, it's a detail that is, you know, easily overlooked in this very emotional debate on the independence of the board, but I think it has to be clearly understood in that. So these are the reasons for which we have decided for a commission secretariat as opposed to an agency-based secretariat. Then coming to, let's say, more, how to put it, more fundamental issues, if you want, although I fully understand that this is an issue that is very important, and I heard very well what has been said in that respect, both from the independent regulators' point of view and also from the point of view of the media freedom community, so both from Mr. La Sorella and Renate, but coming more, let's say now on the setup of the board and its independence. So I think, again, in this very emotional debate, what is often overlooked is that it is an upgrade, and it is quite an important upgrade in terms of the independence of the board, that for the first time, unlike for ERGA, that is simply a commission, a totally dependent body on the European Commission, because a commission expert group, it's simply our expert groups that are at the commission disposal, if I may be a little brutal. And I think it is very clear, it has become very clear to us, and we have been, of course, extremely respectful of the role and independence of independent media regulators in the current setup of ERGA, that it is not appropriate for the type of entities, of course, we are talking about, the independent media regulators that are extremely important, and our independence, we have been fighting for having the independence requirements in the EU law for a very long time. You know, I still remember when I joined the Commission many years ago, we have been discussing for the, you know, for the first time with member states, and especially one big member state has not been very happy about anything about independence in European law of media regulators. And we haven't managed to have anything in terms of independent regulators at the time in the previous revision of the directive. In the last revision, we did managed to have the strong independence requirements, and of course we are extremely happy about it and will be acting upon, because I think Renata has been very clear about the fact that she would consider that the independence is not taken for granted in some member states. So but as you know, I think you have to also understand that the Commission can only act vis-a-vis the member states once they have transposed the rules into their national laws. So, and this unfortunately has been subject to severe delays. And only now we will be able to start looking at the independence of media regulators under the Audiovisual Media Services Directive. But we fully share this objective, and we will be extremely vigilant on that. So now coming, sorry, because I've made a very long introduction, to go back to the setup of the board. The fact that the Commission, so a bit, going through the main elements, the main features. So the fact that for the first time, the independence of the board is recognized, as opposed to the current status as a Commission expert group, I think is quite significant. I think you will have seen the language. It is a very strong language that, if you compare, to other independence requirements that we have for similar bodies at EU level. And I thank Mr. Lasorella for recognizing this. And then, and it really reflects a clear conviction on the part of the Commission that as the independence of media regulators has to be ensured at the national level, the same should happen for the board. So a clear improvement to the situation of today for media regulators and for the network of media regulators at EU level, ERGA, the board as opposed to the current ERGA. The Commission presence in the meetings of the board is something which is present in any independent body that the European legislation has created so far in the history of European integration, even for those in very sensitive areas like the Data Protection Board. So this is something extremely natural, and the Commission, as an independent institution that is trying to set up those bodies, of course does not influence the decisions or any other deliberations like here, opinions of these independent bodies, but since it creates them and provides the secretariat, it is only natural that it can be part of the official deliberations, which does not mean that the board members cannot, as they do today even, cannot talk to each other in different settings. It would be extremely, it would be unthinkable for us not to have the Commission in the meetings of the board, as I said, is the case for any comparable body at the European level. Then on the involvement of the Commission in the different deliverables of the board. Maybe starting with generally the whole idea is to limit the involvement of the Commission to the absolute minimum that is necessary under the treaties. So this has been the guiding principle when we try to look with our legal services at the role and independence of the board. I'll give, let's say, 3 examples. The first is the possible involvement of the Commission when the board decides who will be observers, in particular the so-called permanent observers to the board. And I can only tell you that the situation that we have foreseen for this particular board is the most privileged as opposed to any other body that exists at EU level. To give you an example, for BEREC, it's the Commission that decides. So I think it's very important. And today, just to be very clear, it's the Commission that decides. So I think it is very important to see that, it's an improvement as opposed. So the fact whether the Ukrainian regulator will be sitting as a permanent observer in the board, we think that this should be a common decision of the independent media regulators and the Commission. Not the least, because I think it is also understood that it is the Commission that takes the responsibility for the meetings that we organize and also pays expenses of the people that come to the meetings, which is a completely different argument, a subsidiary argument. Then we are looking at 2, and this has been already mentioned, 2 possibilities as regards the substance of the work of the board. On the one hand, we have issues that pertain to the functioning of the current audiovisual media rules that, as you know, are governed by the country of origin principle, both in the audiovisual directive and in the e-commerce directive. So the reason why we have decided to have the safeguard of agreement of the Commission in those cases was not to intervene in the substance of the opinions of the board, but just to make sure that we would be able to signal, and this is really important, I think, from the perspective of the regulators that will be recommended measures to, that this is happening within the framework of the existing EU law, that the Commission is, of course, the guardian of. It is up to us to interpret whether the country of origin has been respected or not, and not the role of the individual regulators. So I think that this is important to understand that this is the only reason why we have involvement of the Commission in the cooperation part of the legal act that pertains to the regulation of video sharing platforms, or, for example, the Russian propaganda decisions about the Russian propaganda channels that are being taken. So I think, just a point to Renata, I think it is, I heard you don't want the Commission, and of course it's important that these decisions are taken by the independent media regulators, but at the same time we have to make sure that this happens within the limits simply of the competences that have been given and preservation of the internal market. Then we are coming to very sensitive areas where we do foresee no involvement, no agreement of the Commission whatsoever, but simply the possibility for the Commission to ask opinions to the board. And while we have foreseen the request of the Commission in those cases is very clear, because as you will have noted, that these opinions will be in cases that are likely to affect the functioning of the internal market. And we think it might be very difficult for the board to identify the cases that are of internal market nature. So we would like to help the board and also protect the board from pressure to express itself on a number of national situations that we think would not be for the European board unless they decide. So nothing prevents in the proposal, as it is already the case today for ERGA, to formulate own initiative statements, opinions, but they would not be on the substance that we have foreseen on the proposal, which is about the impact on the functioning of the internal market. And one last element to bear in mind, which I think is important, in that on the independence of the board, is that the Commission, as you will have seen, does have a possibility to formulate its own opinion, but only after the board has pronounced itself on a certain issue. So it really is also to show, very clear separation, that it's not something, that the Commission wants in any way have any say the content of the opinions that the board will be formulating. So I know I have been very long, but there is a lot of emotions around independence of the board. So I wanted to clarify those issues for the debate going forward. And then coming, if you allow me, Elda, one sentence or two sentences to refer to the justified concerns that were expressed by the EPC from the, let's say, point of view of non-regulated media service providers. So this is, as we have explained already, very clear in the proposal. All the rules except the so all the rules that pertain to the entire media market are very clearly outside the competence of the board. I heard you that you might be worried, that the co-legislators might change it. Well, it might be, I think, relatively difficult for the co-legislators to do so, but and we have not heard any indications in that direction. But this will be one of the major points of the Commission that the Commission will defend until the end, we think, that we understand that certain, and this is, for example, recognized in Article 17, that there is a subset of media, printed, written media, that is not regulated in terms of its content in the member states, and we do not want to change that. So this is very clear. So this separation, the role for the board only for Chapter 3 is a very important point for the Commission. And as to your point of possible impact spillover, if I understood a bit of effect on, let's say, the impact of media regulators on the press sector, on article, specifically on Article 21, because this was the one that you have mentioned, and I think this is the only one where we would, you know, understand there might be such a spillover effect, that you might be concerned about it. It is very clear in the proposal that we are here talking about media market concentrations with significant impact. So I think it would be extremely rare that that media market transactions in one media subsector, like the press, you know, would be captured by this notion, because we are really talking about huge operations where normally different businesses, not only in the media sector, by the way, might be concerned. And even if, you know, I think what we, or how should I put it, what we wanted to make sure is that some member states might consider in exceptional cases also such operations, and we know some systems do capture operations, like, for example, in Ireland, you know, operations in the press sector, we understand, are being looked from the media pluralism perspective. So we do not want to take away this possibility, but we are not asking member states to foresee additional competences for the press sector if they do not exist already under their current systems. So I hope that that clarifies that point, which is very important. I understand, both for you, but also for us. I'll stop here. I'm sorry if I have been very long, but I think it was necessary to clarify certain misunderstandings around the Commission proposal.
Okay, thank you for your clarification, your enlightening remarks. And there is a question in the chat on from Eragil, I assume. Couldn't the media program just be used to fund ERGA Secretariat? And a comment from Renate: I wish to clarify, it's not emotions, it's coherence. Thank you, dear Anne. So I wonder whether there is half a minute to answer to Erard, and then we immediately give the floor to Eva.
I can clarify simply that already today ERGA's activities are funded by the Creative Europe program, and this is the plan. And we explained that in the financial statement that accompanies the proposal, that it will be the Creative Europe program indeed that will fund the Commission Secretariat to the new board.
Sorry, I see that there is a raised hand by Giacomo La Sorella. Maybe he wants to intervene, or is a legacy hand?
Just a moment. I also wanted to say that also my intervention was not emotional at all. We are just discussing this very clearly, and I must tell Anna that I fully understand the point of view of the Commission and the good faith of the Commission, but I think that there is a legislative process for this reason. I take good notice of the point of view of the Commission. I think that this legislative process is aimed at ameliorating the text. And I think that the relation among the NRAs and the Commission should not be at the trade union entrepreneurs level, but we should cooperate to find the best solutions for regulating the sector. So I understand the point of view, the constraints, also the economic constraints and the legal constraints that affect the Commission, but I think there's room for finding an improved solution, starting from a point which is already a good point, but can be improved. Thank you very much.
Thank you very much to President La Sorella, and definitely we agree on this perspective. And without further ado, I give the floor to Eva Nenadic for the last panel. Thank you.
Thank you, Elda. Thank you, everyone. I think the discussion so far has really showed how important this piece of legislation, even if just a proposal is, and how important it is to discuss different aspects of it. So we always have this run against the time. We now reached our third and the final session of the day, which is about content of media service providers on very large online platforms. And I'm very sure that we will have a very lively discussion around this one as well. I will just give a very brief introduction into this topic, and then we have our three relevant stakeholders and speakers for this session, starting from Lubos Kuklis, who is a former chair of the European Platform of Regulatory Authorities, so-called EPRA, or better known as EPRA. Richard Burnley, who is the Director of Legal and Policy and General Counsel at the European Broadcasting Union. Anja Helseth, who is a Strategic Policy Manager for EU Affairs at Meta. So I think the aim of this session is pretty much clear from the very title, and I'm sure all of you have read the Article 17 that is at the core of this discussion, and also Pierluigi showed it at the very beginning of today's event and of today's meeting with everyone. I would just like to add that our starting premise somehow here is, or the starting point that is, I think, relevant to mention is the fact that very large online platforms increasingly stand as intermediaries and as gateways between citizens and their access to news media content. So platforms terms of service and policies on content moderation, but not only content moderation, also curation and ranking have impact on both exposure diversity as one of the key elements of media pluralism and informed citizenship, and also on media business model, as the media increasingly rely on online platforms as a source of traffic to their sites. So this is why I'm saying this, because this shows why it is important and relevant to discuss the relations and power distribution between those who produce content under editorial responsibility and those who algorithmically distribute content without editorial responsibility. Pierluigi at the beginning mentioned that we already had a similar discussion related to so-called media exemption under the discussion related to the Digital Services Act. And in fact, we at the Center for Media Pluralism and Media Freedom hosted one of these discussions when it was a time for them. I would just like to remind about some arguments that were used back then in relation to Digital Services Act and the relevant European Parliament's committees who were proposing this amendment to the DSA. They were suggesting or arguing that commercial online platforms should not be allowed to exercise a supervisory function over legally distributed online content originating from service providers who exercise editorial responsibility and consistently adhere to union and national law, as well as journalistic and editorial principles. So as already has been said, this amendment was not adapted to the DSA and didn't become part of the DSA. But now in the proposal for European Media Freedom Act, we have Article 17, which we can simply describe, and Pierluigi already did, as special treatment for media in content moderation by very large online platforms. So just briefly to remind what this article is about. First, it somehow requires very large online platforms to provide functionality for media service providers to declare as editorially responsible and independent from member states and third parties. And then the platforms, in case of intervention with their content within their content moderation activities, they should communicate reasons before the takedown or other action on this content to the media service provider, and they should allow that any complaints are processed with priority, or they should make sure that this happens. There are some other issues from the very article that I'm sure we can touch upon in the discussion. I would just like to open the discussion by saying that while it is clear that more power should be restored by the editorial responsible media in the online distribution of their content, there are also many open issues and potential loopholes, especially when considering specific member state context and the overall implementation of this provision once and if adopted. For instance, is this giving platforms even more power over media? Why the focus is only on content moderation, but not on curation and ranking? Is platforms, if platforms just downrank media, then would this mean that it would slip out of this provision? And another side of the issue that we would like to tackle in this discussion is that who will in a way validate if media who declare editorial responsibility and respect of professional standards indeed comply with those? Because while media should be key in fighting disinformation, we very well know, and also from the available academic research, that media often contribute to the problem of disinformation with clickbait strategies, sensationalism, oversimplification. And this is also opening another area that we believe should be discussed here today. At least we should try to start discussing it because the time is in a way limited. So without, again, further ado, I'll leave the floor to Lubos Kuklic to start with the discussion.
Thank you, Eva, and thanks to the EUI for having me here. And it's great to see all the colleagues here, albeit only online. Indeed, we already had this debate a few months ago together, and I do think that it is an important debate, and it was an important debate within the DSA framework. And I think it's a kind of good thing that it wasn't included in the DSA in the way that it was proposed, and the proposal that was circulating in the European Parliament, because of the many loopholes that were really quite glaring at us and at the moment. And especially from the point of view of disseminating harmful content, including disinformation, because, you know, if anybody can self-declare themselves a media and then, you know, would follow the rules that were written there, it just wouldn't be good for society as a whole, not only the digital environment. Now, saying that, I do think that there's some kind of special treatment is really something that should be considered. And I'm glad, for that matter, that it is included in the framework of the European Media Freedom Act. But I also do think that there are some points that would better be clarified during the legislative process, and I would like to address them today. Then I would like to also address how this may even unfold more in the future and in a more developed way, maybe in the guidelines that are foreseen in the proposal for the regulation. Now, for the terminology, I think it is quite revealing that in regulatory environment we keep calling this provision a media exemption, and from the colleagues from the platforms keep hearing that they are calling that must carry obligation. I think, you know, this terminology is not quite right. And probably what Pierluigi used today as a kind of special treatment maybe is much closer to what's happening here, and probably also the terminology. It may be a kind of reason why this debate might be quite heated, but I think we have to sit down and talk about it really constructionally. Now, we've heard many objections, you know, before during the DSA debate, but I'm hearing those objections also too. And for example, from the point of view of people that are dealing with disinformation, they still think that this provision might be a threat. And they are saying, for example, that, you know, the same kind of procedure can be foreseen within the framework of Code of Conduct within the DSA. Well, yes and no. I think for the media, we really need something much more stronger. We need something that will keep a certainty for the media providers that, you know, the vector of disseminating of their work via social media, for example, can be somehow limited because of the arbitrary decisions of the social media providers. So it is, I think, very good that we may have a kind of legislative framework for this. Now, what is written in the EMFA is a bit too vague from my point of view, and I will clarify at least 3 points there. For example, one of the recognition of the media, one of the criteria for recognition of the media that are to be subject of the special treatment is the regulatory framework already existent, for example, in the member state for editorial decisions or editorial processes. Now we have to be very careful about that because, for example, there are provisions within AVMSD that are implemented in the member states frameworks, but those are never, for example, about disinformation, and very seldom there are, regulating anything connected to online. So, for example, you may have media in the member state that obliges for all the rules there. But, for example, this wouldn't somehow limit them to disseminate disinformation, or if it does, it may not limit them to disseminate disinformation online. So we have to be careful when just giving a kind of blank check for being under some kind of regulation that already that kind of media can be subject to this kind of special treatment. I think also there needs to be criteria for those self-regulatory framework that are mentioned in those criteria for media that can be subject to this special treatment. But on the other hand, and it is not clear from the substantial provisions, but it's clarified in the recitals that it also is to be somehow up to the social media themselves, the providers themselves, or very large online platforms that can decide whether somebody or some organization is fulfilling those criteria or not. And I think we also need to have accountability structure or enforcement, if you will, for this kind of recognition. I don't think it should be up to the platforms themselves just to decide about whom can be subject to this. Now, Eva already mentioned this, but the first part of the article is talking only about suspension. There are also restrictions then mentioned a few lines under that. And I think this should be definitely clarified. And I think that this article should also encompass the restrictions, meaning, some kind of limited circulation and these kind of things. So it should not only be about a outright suspension of the content there. And now for the future, I think there's now a great opportunity to connect these provisions to self-regulatory structures that are already existing in the member states, for example, or on the EU level. But it can also foster much more of this to the future. Maybe even not only the organized media or the institutionalized media, but also some autonomous journalists can then create organizations that can connect to these provisions, and it can also maybe then foster the new content, new quality content, so to say. And I don't want to go too much into detail, but for example, there's an idea of my friend Martin Husowitz from London School of Economics around trusted content creators that is now circulating, I think, a bit, and we are working now together on how to connect this to the Media Freedom Act. But I think that the work to elaborate on this can really then fulfill the purpose of the EMFA in this regard, and to foster some quality content. And I think those guidelines that are foreseen in the EMFA now and in Article 17 can really be the vector through which these ideas then can really help the environment. And this is also where this connects to the DSA, because DSA is quite relying on active participation on the various stakeholders. And from EMFA perspective, it could be media and journalists themselves, that they really need to actively work on organizing and actively work on using those provisions, if of course put in force, to help themselves and help the media environment as such. And here I would stop. Thank you once again.
Thank you, Lubos. Just briefly to build up on what you said or what you suggested, that there should be connecting the intention to connect this provision with effective self-regulation. One of the discussion that we've been dealing with in the past couple of days was the idea that some countries it was also addressed previously in relation to other provisions of the proposal for European Media Freedom Act, the fact that European countries are so diverse on many fields, And one of the aspects is also the existence of so-called or any form of media councils, and whether the existence of a media council could be something that could be connected to this provision, thinking of media councils as a self-regulation that could have mechanisms to somehow ensure that some kind of oversight over who benefits from this special treatment, or who can actually declare as media with full editorial responsibility. So moving on to Richard Burnley. Richard is with us. Yes, okay, now I see you. Please go ahead, Richard, the floor is yours.
Thank you so much, and thank you so much for the invitation to speak at this important event on a very important initiative from the EU. Again, it's been heard several times today. I'm speaking on behalf of EBU, Association of Public Service Broadcasters, and we haven't got our final positions like many other associations at the moment, but it also, of course, gives me a little bit of freedom maybe to contribute and to have a little bit of a brainstorm really about Article 17, and which I think is a little bit the purpose of today. I think first off, it's really great from our perspective that the EU is trying to tackle the superhuman power, one might say, of online platforms, and recognizing that regulation is needed, not only to promote independent and pluralism, but also protect the output and the content of European media. You know, to those who would say commercial freedom of platforms has to be respected no matter what, I think we would never agree with that, and not when they're so big and so important to society and democracy. And you know, let's not forget that EU law has a long tradition of promoting access to essential facilities in competition law. And here, you know, we're not only talking about competition, we're also talking about democracy and pluralism and the health of our society. So regulation and protection is absolutely important. We could have another long session on findability as well in Article 15. That's for us is crucial, public service media. But we also need to be protected from being taken down, and has been said already, and blocked by platforms in an arbitrary and commercial way. We welcome in that respect Article 17. Broadly, we do as an association, and it builds, of course, on the transparency obligations already in DSA, which brings me to maybe just a few comments that would be personal at this stage, as I say, but things that I would raise about Article 17. I think overall it's a step forward from DSA, as I say, which only offered weak protection to we broadcasters, and you know, based on transparency, and I think we have to face it. If somebody treats you badly, it doesn't really help you if they tell you about it openly. You know, that's not enough. We need protection. We need a kind of structural protection. So Article 17 is a good step. I think personal reflections I would have is that there is an argument, surely, perhaps, that public service media fulfilling the obligations in Article 5 and also their strict national regulations could possibly have greater protection under Article 17 and against takedowns. You know, why would a platform be able to take down public service media content according to its commercial standards that's already heavily regulated, not only in its own country, but then fulfills the strict obligations of the MFA and the independence obligations of the MFA? So there's some logic there in thinking about that. As I say, it's not our position, and it's occurring to me personally, but I think we'll put that aside for now, as probably some people would like us to. I think other things just generally that strike me reading through it is the balance of Article 17, and for me it's still a little bit skewed towards the platform's favor, to my liking. You know, now they have to notify broadcasters in advance before pulling down content, but they can still pull down content and answer questions later. And let's remember that a lot of these platforms are vertically integrated and they're competing directly with us. So they have no real commercial incentive to treat us well out of charity. And I think then the question is on the mechanics of the provision, how might it be rebalanced? And again, just some ideas to think about. Firstly, might be the scope might be enhanced, and I think this has already been mentioned. Not just triggered by takedowns itself, but also by disguised takedowns, or what you might call shadow banning of content, i.e. demotions and putting things online and content online in far off corners of the web. It has the same effect. So I think something broader around that might be interesting for us. I think the definition of very large platform, going back to DSA based on volume, we need to look at that as an association and make sure it covers all the essential platforms for us. Some platforms may not fall into that category, but still be too powerful for us to deal with. So that's something that we'll be looking at together with our members. And thirdly, and it's a kind of variation of what I started with, more nuanced maybe. Should we be thinking about where registered independent broadcasters have some kind of greater presumption of innocence? That is, they have some sort of right to be heard before the content is taken down, a chance to explain before the content is taken down, maybe a presumption of innocence that would be lost in the event of repeat offences, and that merges into to some of the provisions and constructive dialogue and things like that. Seems to be the logic of MFA a little bit, if you're fulfilling the independence obligations there. Again, we'll have to work that through with our members. I think a final point I would make is again about the balance. Very large platforms under the MFA must deal with complaints without undue delay, which is better, and it's a step forward from the DSA, which talked about a timely way. That was, fairly loose. But I think we still would want more urgency. We'd still want something, even prescriptive, maybe something like 48 hours. Again, it's just personal view, but something a little bit more urgency and a little bit more incentive for platforms to take this seriously and put sufficient resources into the whole procedure. First reflections, but this issue, I just have to stress, is very real for us. And we are generally regulated at national level. We will be regulated by the MFA. We do have plenty of examples where some of the big platforms, Facebook being one of them, has taken down content reporting on for example, the French-Belgian broadcaster had content taken down just reporting on police violence generally, because it was said that was to protect minors. We've had WDR, ARD, German content taken down from one of our members simply about a terrorist attack in Germany, no explanation. We've had YouTube take down Swiss PSM content on police, some content on police repression in Russia, which they said was to protect minors, and and that's just to pull out a few, not to pick out any particular, because we've had issues with all the platforms, and one could say they're all at it in some way or another from time to time. And we need quick, fast resolutions. It can take many weeks to get that sorted out and to get the content back again. So yeah, I think overall we support Article 17. It needs to have some rebalance maybe and some clarifications. Thank you.
Thank you. And now moving on to Anya Helseth to give a perspective of a very large online platform, in this case, Meta.
Yeah, thank you so much, everyone, for having me here. And of course, looking forward to the discussion that I'm sure we'll be having after we all finish with the interventions. But just to set the scene a bit from our perspective, we obviously at Meta absolutely agree with the goals and principles that EMFA is driving at, which is basically media independence and media pluralism are the cornerstones of European democracy and freedom. We obviously also agree that well-functioning and stable and independent, more importantly, media ecosystem is the pillar that can really ensure media pluralism and all the values that we are discussing here are preserved for all our citizens in the Union, including, of course, our users using also Meta services. We are very happy when it comes to European Media Freedom Act. Let's just start from the first articles, that it's framed and based on existing legislations, namely DSA, AVMS references those, and therefore doesn't come in the vacuum, because there's no vacuum here of rules governing content moderation and requirements platforms has to fulfill also when it comes to terrorist content regulation, when it comes to copyright rules. Also, by the way, funny enough, Article 17 there. So those provisions that kind of frame EMFA are quite important from our perspective, and we definitely will be encouraging when the legislators will be working on those, that they kind of come back to those reference points. Moving to the definitions, and after that to Article 17 itself. The initial, I think, issue that we obviously, because I guess you, the audience, might be aware that we are not maybe as welcoming to the Article 17 type of exception. But one of the reasons for it is that, first and foremost, the definition of the media service provider, the way it is currently described, is really, really broad. And it puts a lot of onus on the very large platform, in this case, for example, Meta, to kind of, validate or not validate. Basically, literally anyone in the digital kind of space can declare themselves to us as the media service provider, and therefore require us to follow the process of our, this is really prone to abuse, and it's really then easy to kind of circumvent content moderation rules, which, as a reminder, provide for safety of our users, to prevent also the spread of disinformation, to address certain types of content that are violent, encourage to hatred, etc., etc. We don't have content moderation rules on the platform to prevent people from engaging on free speech or interacting with news, or interacting, generally speaking, with world kind of worthy information events. The content moderation rules are there for reasons that also, drive our platform towards providing safety of the users. So in that sense, we of course have some concerns right now about Article 17, namely because of the very broad categorization of the media service providers. And also quite many still issues there for us to even kind of navigate, because in some cases we are a media service provider as well towards other players in the space. So even that creates already quite many question marks, but broadly speaking, towards the rest of digital ecosystem. The belief at Meta is that content moderation rules should be applied to all users of the platform in an equal and fair manner. So obviously there were some already examples that Richard, I think, brought up that I'm not familiar with because he hasn't shared them with me ahead of this panel, but it is, of course, not new to this group that was engaging with us on a number of files such as DSA and copyright in the past, that content moderation rules has its limitations, to the point, especially when it comes to content takedown, and especially, and in particular, when it's under time restriction, which leads then to liability. There are mistakes that can happen, and it's never going to 100% correct. So I definitely can confirm there were, generally speaking, some mistakes. There are, generally speaking, also some mistakes due to wrongly reporting to our rights manager of licensing obligations. So for example, it can happen that one player did not inform another player that they logged in certain type of content into the rights manager, which is our licensing program, that this content belongs to them. So then automatically, if someone else uploads the same content, which they might have right to, this content will be taken down. But that's, of course, a separate discussion that pertains more to the copyright rules. Coming back to content moderation principles, our our priority is when we engage on those, when we kind of look at our community standards, is to make sure that people feel safe, that while people can engage and should engage in the difficult discussions, they do it in a way that doesn't threaten certain communities, that doesn't encourage to hate, and doesn't expose people to images and visuals and videos that might be upsetting them, at least without warning. At least without warning screens, and of course towards minors, the rules are even more stringent per the AVMS rules. So yes, of course, when we saw in DSA this attempts to include this treatment of media service providers, our concern was again that this is a very broad range of actors that would be basically taken out of the content moderation principles. And therefore, the concern was whether those actors actually could potentially threaten the health of the discussion, because we are not always talking here, let's remember, about members of the EBU or reputable press publications such as, I don't know, Le Monde or The Standard here in Belgium, or number of other periodicals that I'm sure all of you interact with in your member states. We also talk about other types of players that would be covered by this provision and would therefore benefit from the same level of protection. And there's a number of titles that I'm sure come to everyone's mind that would definitely not play by the rules that you were describing. So this is the concern that we as a company have raised already during the DSA discussion. We're still preparing our response on the EMFA for the European Commission consultation, but of course, this type of consideration and concerns will be included in our submission. So I stop here and would love to hear some questions or follow-up discussions.
Thank you, Anya. As we need to leave at least 5 minutes to Anna Herold for final remarks or reflections on this session, I would say that around 10 minutes we have now for questions and for comments, for discussion, wherever you feel that needs to be said in order or in addition to what we've heard from the three speakers at the introduction of this discussion. So please, the floor is yours. I will try to see if anything comes up in a chat. But anyone also who is joining us online is more than welcome to step up and Maria, we see Maria Luisa, please go ahead.
Yes, thank you very much. Thank you to the three of you for sharing your opinions. This is a very complex discussion, I would say, as a free speech organization, especially. It's one of those discussions where nuances are vital, and we felt we had part of this discussion at least under the DSA, but that's back with different elements here. I have to say I loved what Richard said when he said, well, one thing is to have transparency, but even if I know that I've been treated badly, then it's not enough. And I couldn't agree more. And I think I really want to link this with a question about Article 17. It's still not clear to me 100% what is exactly the challenge that Article 17 is supposed to address. Because if the challenge, the specific challenge is supposed to be addressed by Article 17, is that we run the risk that many media service providers, therefore a lot of media content, news, current affair, but also entertainment, is in a very weak negotiation situation with regards to very large online platforms, and this is so because the very large online platforms are just a handful, and they have a lot of power. Then I wonder if the situation, first of all, I think this situation is not only a media service provider problem, but it's a societal problem. And I wonder if the solution to this challenge is to try to fix and create guarantees and fast tracks and specific channels for this negotiation to happen, or if another solution could be the one that Richard, I think he mentioned or hinted to, which is if I am unhappy with this sort of relationship, can I go somewhere else? Do I have other options? In other words, what I'm trying to figure out is, would Article 17 be so important if we didn't have so much concentration in a specific part of the value chain, and would rather thinking about how to dilute this concentration in that specific part of the value chain be an alternative, sorry, not alternative, accumulative solution as well?
Thank you, Maria Luisa. Would someone from the speakers would like to react to this, or maybe someone else from the participants? Also, the floor is open for other questions as well. I see Lubos raising his hand.
Yes, thank you very much, and thank you, Maria Luisa, for the intervention. Yes, indeed, if the situation and the the occasion where that they are, probably this provision wouldn't be needed. But the thing is that it is addressing situation as it is. So yes, I think if the situation changes, then and changes for the better, there wouldn't be that much concentration. Then probably this provision then can be dismissed, or the legislation can change. But I see this as a kind of remedy to what we already have, and that the media are really in the dire situation that they are. So as the EMFA is there to help to better the situation of the media, I think this is one way to do that, but this doesn't exclude other ways, as you mentioned. Thank you.
Thank you, Lubos, and now moving on to Richard.
Yeah, 100% agree with what Lubos says. I mean, I think that these platforms are absolutely essential for us to get our content to viewers now and in the future, even more so as distribution goes more online. And competition law gives certain tools, but it doesn't give the tools to deal with the kind of organic growth that we've seen of these platforms, and this is the issue. And therefore, some kind of regulation is absolutely needed to protect and promote European media. But it is a problem of concentration for sure.
Anya?
So my quick reaction to that is that I always am a bit wary when we use word platforms. Each of the platforms, despite they might look very similar to us when we watch content or interact with content, they have very different kind of goals in mind. I mean, if you take Twitter versus Meta versus Amazon versus Google already, and TikTok, by the way, which is another big competitor coming into this space, they interact with content very differently and with very different audiences and in a very different manner. I do want to stress that Facebook and Meta, and that our CEO made it quite clear in number of very public engagement for a while is, focusing on content that links you to your friends and family content. So I also want to frame that part that the priority of the company is to link friends, family together with the content they post, which might be news related content, to be sure, because you might want to be sharing some news, but it is not serving purely for the dissemination of the media type of content for the companies who are represented, for example, by EBU or other media players. So I think that's quite an important reflection as we speak. What are the obligations of those companies in terms of dissemination of such content? And nobody says that we don't want to disseminate this content or we want to block it by applying content moderation. I'm just saying that all these platforms are not actually the same, even they might look the same or feel the same when we interact with certain types of content that we used to interact. So, let's coming back to Le Monde, the article on Le Monde will look very similar on Twitter, Facebook, and perhaps, YouTube will have harder time to disseminate that, but video the same way on each of those platforms. But the way it is disseminated is also through the lenses of the goals of each of the companies. So that would be my addition to that discussion.
We have also one question from Sofia Verza.
So just a quick reaction on this last note from Anya. So I would just point out that this last reaction pairs with the initial observation from your side that also media service providers are not all the same. So the difficulty of offering solutions that differentiate the different intentions or ratios behind the company is valid in both directions. I think if I hope I made clear what I mean. Yes, that was it.
So it was more of a comment than a question, but still useful for the for the discussion or for future thinking about this proposal. So if we don't have further question or additional question from participants, I suggest also considering that we are approaching the end of this session to open the floor to Anna Herold to give her views on what has been said in this session. Go, Anna.
Thank you very much. So again, a very interesting contribution to the debates as the other two. Thank you to all the panelists and those that intervened. Maybe a bit summarizing on trying to, how should I put it, reconcile the different positions that were expressed, a word on the rationale of this provision, and in a way also a little bit, you know, why we think we are now in a slightly different context than the one when this infamous media exemption debate was there in the context of the DSA negotiations. So I think that was already rather eloquently referred to by Richard, and it also links maybe a little bit to the point by Sophia. We are introducing at EU level now rules, common standards for editorial independence. And by the way, not only for public service media, also, I mean, you have explained, Richard, you know, that there are very specific rules for those type of media service providers, but for all of them. We have discussed it at the beginning of today's conference, no, Article 6, and the whole surrounding framework that we are trying to put in place with a certain difficulty, obviously, because these are not easy issues. So I think that's the whole idea of having these safeguards in place. If we think that all media service providers should comply with certain minimum standards at EU level in terms of their integrity, it is only natural that online, the content provided by such media service providers online will also benefit for certain safeguards, that this integrity continues to be there also for online, in terms of the possibility of this content to further reach viewers. So this is a bit where we are coming from with this article, and I think we have little doubt that media service providers that are either regulated or adhere to universally applicable self-regulatory standards within the member state, which I think is a bit, how to put it, a bit overlooked when it is being discussed. You know, everybody will benefit from this, and it is very easy to qualify. I think it is a little bit difficult why they couldn't benefit from a certain privileged treatment, because I think also, you know, to put it also in the perspective, and I understand that might be some players on some voices in the discussion that might not go far enough, so I fully understand, but I think we are trying here to give them certain benefits vis-a-vis those that distribute their content, certain privileged treatment in several areas, one of which is ex ante, and the others are exposed. I fully understand that you might, from the point of view of the media service providers, or also in general from the point of freedom of expression, discuss whether those safeguards are appropriate or sufficient. But at the same time, I think what we are trying to do, and this is the, how should I put it, a bit of a a gesture, you know, to the points that Anya has raised. We are, of course, here in a very sensitive field in which we are trying to arbitrate between freedom of expression on the one hand, and also freedom to conduct business and to address and create safe conditions for the viewers by certain media players that have, how should I put it, reached this maybe unwanted role, you know, of being this gateway to content by people. Wanted or unwanted, you know, it's more of a philosophical question, of course. So I think that we are trying to put something in place that makes sense, but at the same time preserves this possibility for those players to set their terms and conditions. So I think that this is very clear from the character of this provision as well. And then maybe one point of clarification, because this was raised by Lubos. In the part of the provision that refers, let's say, to this ex ante possibility to have this prior statement of reasons, that is clearly a new guarantee that does not exist so far under the platform to business regulation. So this is a clear improvement for media service providers. You have rightly noted that this refers to suspensions. So the type of, let's say, the most serious types of measures that might be taken erroneously or not by the platform. And then it does not apply to restrictions, while all the ex post instruments, so the privileged, let's say, treatment in terms of complaints and the dialogue refers to both. And this is a bit the response that we have tried to give also to those that you have also evoked, Lubos, that are worried that these ex ante obligations of prior statement of reasons would discourage disincentivized platforms to act upon disinformation, as we know that normally the tools vis-a-vis disinformation are based on restrictions. So, for example, demotions, demonetization, other types of measures. No, I don't have to explain this to Lubos, that knows this area extremely well. So this was the reason for differentiating between giving the possibility on this prior statement of reasons for suspensions only, while the other ex post instrument, of course, are for both types of restrictions. So for both types of measures that platforms may take, suspensions and restrictions. So I think that that's what I would say. This is, of course, just the beginning of a debate. But I think there are very few voices in the debate that think we should not having this debate, because I think in any democratic society, this is something that we could not have left without an answer after the DSA negotiations. So I think that this is something that is certainly one of the probably most difficult, but also the most needed elements that we have proposed with the European Media Freedom Act. Thank you.
Thank you, Anna. Thanks, very many thanks to all the speakers of this session, but also of other session. Even though we understand that we are at the very beginning of discussing the proposal, this was very fruitful discussion today. I have to say, this is at least my humble perspective on it. And we are also perfectly on time to pass on the microphone to Pierluigi Parcu to give some concluding remarks of the 3 sessions that we've heard today.
Thank you, Eva. I have very few minutes, and so I will be extremely short. Let me say that there are many streams of this discussion that are particularly interesting. So any selection is idiosyncratic. So I will select the ones that I think should deserve anyway some more also scientific thinking, academic thinking, besides the discussion, the discussion of stakeholders of real activity interest that is important, that will be done. Okay, if I can indicate 4 or 5 of these. One is that strikes my mind is this question of the distinction between the individual editorial decision and the editorial line. This is something we need some more thinking. I think is important for understanding the working of the media, and that's in the European Media Freedom Act to relate well to the media issues is very, very important. A second element that I would like to see more thinking is this question of the opinion forming power that is mentioned also in the article 21. And this is very important because somehow in a time of disinformation, this question of what is the role of media in the opinion forming power is very, very important, very central. So we have to wonder about how media can contribute to a better public discourse, democratic discourse. How can they contribute to form the opinion? At the same time, we don't want dominance, as we discussed. So we have this equilibrium and this reflection that needs to be done in a more advanced way. And I think that one of the, I said this other times, one of the most important things of having a European Media Freedom Act is to having a discussion of how our society is going, how media are affecting, how we are paying this information disorder, as was been mentioned. So I think this is also important also for trying to deepen on certain issues. On a more practical thing, I think that another thing that is important was said today, and this is something to think about was the second part of the panel, is this issue of the reputational weight of any board of media. I think this is important because what is really doing this part of the act, as I perceive it, is trying to strengthen the media authority independence and also strengthen it through more peer review, more peer relations, creating this relation among member states and media in member states. I think this is very important. It's difficult, obviously, but the weight, the independence and the reputational weight of the new board will be very important in even or not the success of this effort. Another point I think came out in this discussion is the question of the editorial responsibility of media on the on the powers of opinion. That's a point I was underlined before, but I think this is important for the disinformation question. So the issue is editorial responsibility the way to contrast disinformation? How important is to contrast disinformation, and how this act could contribute to this? And I think that it is one of the keys of the future discussion. And this brings me to the last point I wanted to mention on this, that is this discussion also on Article on the Article 17, the question of the relation between media and platforms, bring us to another issue that we need really to go deeper into, and this is the relation between content moderation, that is one thing, and editorial responsibility. And on the other side, content moderation and freedom of expression. And if we manage to maintain, to really understand the difference between these two things that have been mentioned in this discussion, it's important that we understand that this can help both media, platforms, the freedom of expression, so in society in general, to find a new equilibrium, because clearly is a difficult equilibrium, because we have gatekeepers that are private companies with their own targets, profit targets and business targets that are called on meeting very, very essential, important decisions for society. So we need to clarify, help in this. and the relation with editorial responsibility from one side and from freedom of expression from the other are two key points and need to be really, I think, really thought out better. Let me say that everybody here has announced position papers, documents, and things that they are preparing. And I think this is very good because it's very helpful and will improve the debate. Let me say that we also are preparing something. I think we will have our official comment somehow of the Center for Media Pluralism and Media Freedom about the state of the art, trying to contribute. We commented during the consultation, obviously, but we'll have now, I think we are preparing an ex-post comments that will come out in the next weeks. Our will be much less emotional, let's put it this way, because we don't feel directly, we don't have any direct interest in how the things work, but definitely we have an intellectual interest in this. Okay, let me say that, so this is it for the moment. I want to thank all the participants online and here, the team that has organized this discussion, and I think this kind of discussion will be very important for the act to improve and to arrive to a result. Let me, as I say, thank all the speakers for their contribution, also for their views, and we are very interested and wait for your position papers, and when there will be a spreading of these position papers, probably we'll come back with another deeper discussion on some of these issues. And then in conclusion, let me also particularly thank Anna Herold, because she took this strange role that in the World Cup is starting, would have been called libero, even if it's not usual anymore. This position is coming at the end, trying to save what is to be explained at the last minute, and I think was a very special role, and thank you very much to everybody. Thanks.